Looks like you put everything in my queue, which is great. All right, well, let's talk about this. The file number here is 251148. It's alleged that on or about May 10th, you did carelessly, recklessly, or negligently allow a pistol under your control to be discharged. That's a misdemeanor, punishable by up to a year in jail and a fine of up to $500. This is with damage over $50. So they're going to amend it to reckless or careless discharge with damage under $50. Is that my understanding?
That's right, Your Honor. So the 90-day misdemeanor.
All right. Rebecca Lentz is the manager at Colonial Estates. Yes, I remember the arraignment on this. All right, Mr. Bontrager, the charge you're charged with is a misdemeanor punishable by up to a year in jail and a fine of up to $500. They've agreed to reduce it to under $50, which would be punishable by up to 90 days in jail and a fine of up to $100. Also requires a forfeiture of the gun, if I'm not mistaken. I think this had to do with you accidentally discharging the gun through one trailer and into the next one, is the way I recall from the arraignment. Are you going to plead to that lesser charge?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No, Your Honor.
Or promise you anything?
No, Your Honor.
And you've assigned this advice of rights, acknowledging that you're giving up the rights that you'd have if you had a trial.
Yes, Your Honor.
Tell me what happened.
So earlier that day, I had picked up a new gun safe on Facebook Marketplace for $50. Later that evening, I got home, had dinner, put my kids to bed, and it was around anywhere from 10 o'clock to 12 o'clock. And I was putting everything away. And a couple weeks prior, I had gone to the range to safely and to the best of my ability practice with my firearms and get a good knowledge of them. And when I was moving stuff over into the new safe, I realized that I had that I still had my revolver loaded. So when it was late at night and I didn't think anything of it, I pulled the hammer back and then I realized that it was loaded. So for a revolver, the hammer needs to be cocked down in order to release the barrel or the cylinder to empty it out. And so I was trying to do that. My thumb had slipped off the hammer before my finger got off the trigger, and hence it had went off.
All right. Well, to tell you the truth, I did this very thing when I was about 12. I pulled the hammer back on my dad's revolver. He was changing his clothes after going hunting. I went like this, and then I pulled the trigger and shot a hole in the floor. It scared the dog.
Absolutely.
My dad covered for me. My mom was in the bathtub. And he said, oops. But anyway, I'm lucky I didn't point it at the dog or something, but that is careless. But yeah, it went through your trailer and the one next door. All right, not exactly a bad intention offense, but it's a careless one. What do you do, Mr. Bontrager?
For work, you mean?
Yeah,
I set modular homes,
who's your company?
web setup incorporated.
Somebody set a modular home up near where I live and they set it backwards.
Was it over here in Constantine?
No, it was a Fisher Lake.
Oh, I just did one over in Constantine.
This was
not
a couple,
a week ago.
they had the front porch face backwards rather than toward the lake.
Oh, yeah.
So they'd come out and reset it. All right. Well, this carries a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. Did you post a bond?
I did.
Let's see how much bond I have. I'm missing part of the file.
I had
You
paid
posted a
$300.
$300 bond.
Yes, Your Honor.
And we'll do a $100 restitution. So that comes out to $300. Posted $300 of bond. And I'm sorry, your 38 Taurus is going to be grounded up. Firearm is forfeited.
No.
All right. As I said, there are certain things under the law where carelessness becomes a criminal offense. Some of them has to do with automobiles and some of them have to do with guns and other things. But this is a careless act. I don't know how much this 2 small bullet holes were. I did not see a restitution request in here. So I'll just use that. Let me see if I can. By the nature of the plea, it was under $50. All right, sir. You're good to go. Mr. Westbrook, have you ever been down here before on a case?
I'm not, Your Honor. 100%.
I hope it wasn't a bad experience.
Not at all. Very efficient. Thank you. Your Honor.
But you're welcome to come back. All right, you're good to go, sir. I'll use your bond to pay your fine. And the gun will be forfeited, and I'm glad nothing worse than this happened.
Absolutely.
All right, thank you.
Thank you, Your Honor. In candor to the court, I do have an invoice from Colonial Estates. I don't know if that was a formal restitution
How much
request.
was that?
It was for $409. We are agreeing to pay restitution if that is a formal request. We can take care of that at some
All
other
right,
date.
I'll have to do that. So 409, thank you, appreciate that. So that's 609. Less $300 of bond, leaves 309. You can pay it now, or do you need time to pay that?
Need time, please.
I'll give you till October. You can put on your credit card, October 5th.
Yes, Your Honor.
We can take care of that at the window, Your Honor, at that time.
Yeah, you can mail it in with a certified check or money order. Bring in green cash or pay online with your credit card.
Yes, Your Honor.
Discharging the gun in a bedroom is pretty loud. All right, you're good to go. Thank you.
That was 309, Your Honor.
309.
Very good. Thank you.
Thank you, Your Honor.
Thank you.
Have a blessed day.
We're working on it. Miss Gibson, why don't you come up to the podium? I've got Pablo in the waiting room.
He has not appeared.
Oh, he hasn't? I thought he was here. Do you need him for anybody else?
No, I do not. And I have a staff member here that's able to assist as well.
Oh, yes. Let's see who you mentioned that to me. I don't know who else needs an interpreter. Giselle Gonzalez, I think she speaks English. Adon speaks English. Jesus Alcantar, I think we may need an interpreter for him. Let me take care of Miss Gibson and then, she was here and she left. She's still here.
I just have two quick final retrials,
All right.
and I was gonna scoot upstairs.
All right, well, let's do Mr. Nieves and, good morning, sir. This is file 241818 SM, People versus Adan Nieves. Charge here is assault and battery, 2 counts. Here with Tim George, his attorney. It appears we're going to set this for a final pretrial.
That's correct, Your Honor.
Mr. Nieves, are you still on Virginia Street?
Yeah.
What are you doing now? Are you working someplace?
Right now I'm just working for my parents.
Well, you owe me or $550 in that MD malicious destruction disorderly case from last year. When did you last make a payment on that?
Well, I just got out of prison July 16th, so I've been gone for a year.
I guess so. I don't even know what to say about that. I knew that you went to prison and I'll just leave it alone. You're smarter than that. At some point, I hope you'll finally get everything in order. At any rate, are you on probation now?
I'm on parole.
To who?
Jeb. Downstairs.
Mr. Hawkins, you have received a copy of that new violation, is that correct?
I have, Your Honor. I've shared that with my client.
Do you wish to proceed on that with a preliminary and reset that for a final, or do you wish to proceed today and wrap it up?
No, Your Honor, we wish to proceed today.
All right, does the defendant wish to have a hearing on these allegations?
No, Your Honor, my client's going to admit to the violations, like to be heard in mitigation.
All right, Ms. Gukian, you understand that you are entitled to have a hearing on these allegations of the community control violation?
Yes.
You wish to waive that hearing and admit to the violations?
Yes.
All right. Anything on behalf of the state?
Nothing in addition to what was discussed in chambers.
Anything from probation?
Nothing further, Your Honor.
Mr. Hawkins?
Your Honor, my client, as you know, has a myriad of different health issues. She suffered a stroke. She's diabetic. She's got some neurological and cardiovascular issues as well. She knows that she needs to do a better job of making sure she's taking care of herself, and she's well aware that any kind of use of drugs that have not been prescribed for her is going to have a negative impact on her. She's indicating to counsel, and she wants the court to know, despite prior actions, she is committed to trying to live a healthy lifestyle and a sober lifestyle. She's indicating as well to me through the court that she's willing to do any kind of programming that would be available. She's asking if the court would consider sending her to the Monday program to complete that. She wants the court to know that she does have an interest in trying to be compliant and follow the court's admonitions and be open and forthright with regard to her health things. She acknowledges that she hasn't done all the things that she probably could in terms of managing her health to the maximum, but she is committed to it. And she's been, even while she's been incarcerated, through the help of other family members, been trying to have appointments set and push those things forward in terms of oncology, neurology, and things of that sort. So she stands before you, throwing herself at the mercy of the court. She's asking if the court would consider continuing her on community control, sending her to a CBCF, and the alternative, giving her a minimal sentence on an F3 of 9 months.
Thank you. Ms. Gukian, is there anything else you'd like to say?
It was what, sorry.
the program. And oh, good for
Skookie, the problem that I have is that everything that your attorney said, I understand Mr. Hawkins and believe his sincerity, but I have a great doubt in your sincerity. The court has been patient with you. The court has offered you assistance. I've sent you to a CBCF. You use your medical conditions as an excuse and as a weapon. When you are out, you don't seek the follow-up treatment. And I'm pretty sure with your medical conditions as you've described them, your treating physician would not approve of you using illegal drugs, methamphetamines, and amphetamines. I'm sure that that would be contrary to any treatment that he would be ordering. So at this time, the court is going to make a finding that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. So I am going to order you to serve 24 months in prison. You have credit for the 156 days you have already served. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to a discretionary period of post-release control, which means upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. Ms. Nicholson, is there anything else?
No, Your Honor.
Mr. Hawkins, is there anything else, sir?
No, Your Honor.
Best of luck to you, Ms. Groupian. Craig, you ready?
Oh, yeah.
Do I need to turn this off and start it again?
Your Honor, I did put the nollie up.
I got it.
Okay.
All right, these are case numbers 25CR42866 and 25CR42986, the state of Ohio versus Thomas Davis. Mr. Davis is before the court with his counsel, Mr. Newberger, Ms. Nicholson, on behalf of the state of Ohio. With regard to case number 42866, Ms. Nicholson.
Your Honor, we've presented the court with a nollie on that case. The 42986 indictment is essentially a superseding indictment that covers the same set of facts and charges with an additional charge. And so we're nollying that first case as it is covered in the second case.
Okay, anything from defense on the 42866?
No, Your Honor.
Okay, the court will grant the nollie then, and Ms. Nicholson, you need to sign this document.
Oh, okay.
Court has signed it. Okay, so that case is nollie. All right, moving forward, Mr. Davis, we had an extensive pretrial this morning. Mr. Newberger has been diligent in obtaining discovery and reviewing discovery. There's a little bit more that he's going to get today. Mr. Lawson is going to provide him with a jump drive, flash drive, so that he can go up and get the rest of the information. And he's going to review that. I'm going to reset this for a pretrial with me in 1 week. Okay.
Just for the record, I met with Mr. Davis in the jail on the 29th, and we had a brief discussion today. Because of the enormity of the discovery, he knows that when I come to see him prior to the next pretrial, we'll be discussing a possible time waiver.
Okay.
That's all.
All right. It looks like the to be tried date right now is October 7th, 2025. Mr. Davis, the court has a full schedule, but I will move other trials if I have to get this tried in time. So that will not be an issue with the court. Obviously, it's only an issue with your counsel because there's such discovery that he needs to go over and be prepared for. So we'll be prepared. We'll be ready, whatever you guys decide to do. Okay, so I'll see you all next week. All right, thank you all. All right, this is case number 22CR39887, the state of Ohio versus Randy Halsey. Good morning, sir.
Good morning.
All right, you have been recommended by your supervising officer for termination of your community control. Is there anything on behalf of the state?
No, Your Honor.
Victim been notified?
That is, yes, we left her a voicemail and we did not hear back.
All right, and that's only on the unauthorized use of motor vehicle, the other charges.
Yes.
All right, Officer Fisher, is there anything else you wish to add?
Nothing further, Your Honor.
All right, Mr. Halsey,
Yes, sir.
you've done what the court required you to do, so the court is going to terminate your supervision. Congratulations.
Thank you. Thank you for the chance.
Yep.
Oh, man.
All right. Yeah, I'm sorry to even hear that. You and I spent a lot of time making some progress and then going backwards and making some progress and going backwards. At any rate, these two A and B cases precede your prison sentence. So these are not parole violations, are
They were the basis, they were the basis for the parole violations in prison.
So I just did a year for this.
All right. Well, we'll see what the prosecutor wants to do with it. But as far as this matter is concerned, you're free to go on about your business.
Thank you, Your Honor.
And I would like you to start to pay on that.
Yeah, as soon as I can get a job and Joe approves it.
Okay. All right. This is Ms. Balazet, Sonny Balazet, false report of a misdemeanor. We discussed this at the arraignment here with her lawyer, Mr. Tim George. Same thing, we're going to set a final pretrial conference in this matter.
Yes, Your Honor. And Ms. Musselman advised me that that's her last name now, Musselman. But we just need to get some more information.
You look like you're dressed for work. You had your keys in your hand. You want to get back to work?
Definitely.
All right. Stay in contact with your lawyer. I don't believe you owe me any money. Lots of people do today. But you're good to go.
Thank you.
That will be on a Thursday at 2:00. I don't yet know the date. Are you still at the same address in White Pigeon?
Yes.
Murray Avenue?
Yes.
All right, you're good to go.
Thank you, Your Honor.
I'm gonna duck out here for a minute and see if I need an interpreter for Giselle. I don't think I do, but I'm gonna ask.
All right,
for
so
it.
make sure you have that one there. Door always touched so far.
Oh, ha, ha.
If you want to talk about Debbie Bing, that you can, just get transcribed into the record.
Although I just do have not appeared. And Rhonda Eyes was checking. Jesus Alcantar for Jordan Harden is not here. Jose Espinal Lazaro is not here. And we're checking on Luis Alberto Reyes. Tim was just here on that. We didn't make a record on that one. So he's not here. So we're checking on one more. We had 4 that we thought we needed him for, and 3 of them are not here. So I'm not sure. So I'll put you back, but I haven't forgotten you.
Okay, all right.
All right, he's not allowed to wear a Wisconsin sweatshirt to court. Good morning, sir. Now I'm gonna try to get this right. Some people say Avila and some people say Avila, but I'm gonna say Morgan Kenneth Avila.
Yeah, that's fine.
You're here with your lawyer, Mr. Timothy Reed. You're charged with assault and battery. Let's take a look at the actual case. Well, that's why we're looking for it. Assault and battery is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It shows as a assaultive offense. Disturbing the peace is not an assaultive offense. It is a misdemeanor, an old-fashioned simple misdemeanor, punishable by up to 90 days in jail, fine of up to $100. Simple misdemeanor is one that's punishable by only 90 days. It's alleged that on or about August 23rd of 2024, you assaulted someone named Thomas Mayer. And I couldn't find anything about it. There was no bond information sheet, no affidavit, so I couldn't tell anything about what happened. Disturbing the peace, and I say this about every day, doesn't matter who was right or wrong or who started it. Was there a quarrel, argument, or disturbance in a public place? That's what you would be pleading to. Do you understand?
Yes, I do.
Mr. Reed, you agree with that?
I am, Your Honor. The prosecutor had recommended fines, costs, and time served. He was arrested on this at his house.
How long were you in jail?
That day. Yeah, that day.
All right.
He called law enforcement over near Branch County for a disturbance that a neighbor had tore up some property, and the officers just said, "Hey, there's a warrant here." So he ended up going to jail for a little while.
All right. Well, tell me what happened with you and Mr. Mayer.
Yeah, so we had a verbal argument, and he steps at me, and I wasn't sure what he was going to do, so I grabbed him, I restrained him. He went to sleep, and after.
Who is this guy to you?
So he works, so my father-in-law farms, I help my father-in-law, and he sprays chemicals on the crops for my father-in-law. So he was dropping chemicals off, and.
What was the disagreement about?
So every time I see this guy, he's always calling names and just talking a lot. And yeah, excuse me, I've always asked him to stop, and he's always continued, so.
All right, well, is he still working with your father-in-law? I wouldn't think so. All right, I'm over a 1-day jail credit, 1 day, $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's. Joe, why don't you check on that? Sounds like a little. All right.
I believe a $500 bond was posted, Your Honor.
Yes. I don't know if it's, okay. 500 return balance. Let's see, I don't think you owe me any money. A lot of people owe me money today. Like everybody. No, you don't. Oh, okay. I can't see, but I hear all right. I can see pretty well. All right, that brings a closure to this matter.
Thank you. Would you like me to take that to the counter?
Yes, please.
Thank you.
Jordan, do you need an interpreter for anyone?
No.
We'll make a record. You've got a couple of no-shows.
Yes, I did call the hall. They haven't checked in yet, but I didn't recognize anybody, so.
All right, would you call for Mr. Jesus Alcantar?
He and Miss Nickerson were the only ones that hadn't checked in.
All right, oops, this goes with it too. Yeah, I'm caught in two worlds. Sorry, Mr. Avia.
Thank you.
Thank you.
No, well, contact.
All right, Mr. Haley, why don't you come up and have a seat? I haven't heard back from Miss Ives.
She's talking to somebody right now.
Yeah, I wanted to know whether that person needed an interpreter. I don't think she does, but Pablo, we're still trying to run everybody down. As I indicated, 3 of the 4 have not appeared.
Okay.
Jose Lazaro Espinal is Jordan's. Is he here?
Yes, he's here. He does not.
But he does need an interpreter. All right. So, all right. Luis Alberto Reyes Rios is not here, and Jesus Alcantar is not here.
So she does not have anybody.
All right. So I think we're good. The other 3 people have a Hispanic surname, but that doesn't mean they don't speak English.
I will say, when I was initially appointed to Mr. Reyes Rios, but I was able to provide that as a pass back to Tim for a conflict case. His girlfriend called my office Wednesday and tried to make an appointment, and I advised her Mr. George was his attorney. I don't know if he speaks English or not. I can try to pull up the report and see if there was an indication.
All right. Well, at any rate, I'm not going to make Mr. Bayo sit there and wait around. So it does not appear we have any clients for you this morning, but you certainly are entitled to bill for your time. You've been here waiting, but enjoy the rest of your morning.
Okay. Thank you, Your Honor.
If somebody comes rolling in late, maybe we'll call on a panic, but at this point, I don't have anybody for you.
Okay. All right. Thank you. Bye-bye.
All right, we're going to talk to Sean Haley. Good morning, Mr. Haley.
Good morning.
You're charged with domestic assault, and I didn't like it when I saw this come through, and you and I talked about it at the arraignment. Allegation is that you assaulted Tracy Warner. Her mom just died a little while ago.
Yes, she did.
She was a nice lady, knew her for a long time. Anyway, that's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. prosecutors agreed to reduce that to a charge of disturbing the peace. We just did one of those with the last guy that was here. You understand that that is a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. You understand?
Yes, sir.
All right, I don't have an advice of rights here, so I'm going to take a minute. Oh, you got one?
I didn't have them sign it. No,
All
I
right.
didn't have extras.
Well, I'll tell him and everybody else that's here, Mr. Gary, everybody, do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Harden is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You'd have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. You understand?
Yes,
All right. Were you and Ms. Warner in a dating relationship at that time? Michelle? I was going to ask her to call the hall for me for somebody. Well, I'm looking for Janie Gibson.
Janie Gibson, I'll yell in the hallway for you, sir.
All right.
Janie Gibson.
She's a good yeller. All right. So what happened on July 8th between you and Ms. Warner?
Well, Your Honor, I was working. I worked for the landlord and I was in the basement. And I'll put it like this. When
Sir, Janie Gibson did not check in.
All right. Thank you.
when you say no to not giving any money up, attitudes go flying everywhere. As I said, I was working, putting the hot water tank in, and she just kept babbling with me there and my boss there and everything. I'm in the basement.
Who's your landlord?
His name is Ron. I don't know his last name, but we've been together for maybe about nine years, and that's the landlord to her building. I work for him. So I'm there putting a tank in, and she's babbling off. I think what she was trying to do is get me fired at the time so I can be, in the hole or something. So I didn't pay attention to her, try to just keep working. And all of a sudden you can hear things just boom, 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 boom. She was throwing my stuff out of the apartment onto the back porch. So when I came up the stairs and I seen my stuff just getting thrown, I pushed the door closed so she couldn't do any more. After that, I went back to work. I say maybe about 20, 30 minutes, police came. I'm at work.
Well, apparently something fell on her foot and injured her foot.
Probably all the stuff that she was throwing the mines out the door.
Pushed open the door and the chair fell on it when you pushed the door open.
Together, so.
Are you still together?
I haven't seen her since I've been out of jail because I was told not to go.
Did you go to Gay's funeral?
Oh, definitely. Yeah.
All right, but so you sat.
It wasn't a funeral. She was cremated, and then they have a little family thing that they had. And,
all right.
There was no funeral. But yes, I attended.
All right, I guess that's enough for disturbing the peace. Are you satisfied, Ms. Harden?
Yes, Your Honor, it was a disturbance in a place open to the public. I think that satisfies.
Well, I'm about to lift the no contact provision. So you can have contact, but that's up to her. The problem is you don't have any money. You owe me money. I don't want to just give you another fine that you aren't going to pay. You owe $865 of fines, fishing without a license.
Oh, I was trying to figure out.
I'm not real worried about that. Allowing another to violate the motor vehicle code, I fined you $275. You paid none. In your drinking driving case last year, you were ordered to pay $340. You haven't paid any of that, so you haven't paid anything. How long were you in jail for this?
5 days.
I'll give you 5 days jail credit, 5 days. I'm gonna waive the fine. I'm even gonna waive the attorney fee, but you owe me $125. I want a payment plan on all files. Kind of payment plan where you actually make a payment.
Well, see, I can do it every first of the month. You know, pay something every first of the month because I'm on disability.
I'm aware of that.
I didn't.
But you haven't paid anything on these. The OUIL was reduced to impaired. The driving suspended was reduced to a law and other and then you just didn't pay them. But I don't really want to put you in jail for this.
Actually, I had not remembered any of those that I had to pay for, because if I did, I would have been saying something. Now that you brought it to my attention.
All right, I want you to go out to the counter and set up a payment plan on this and the others. I waived as much fines as I could because you did 5 days in jail.
Thank you.
But that one that has to be paid. All right, you can go with the court officer.
Thank you.
Thanks, Sean.
I do have a couple of cases. No, welcome, Mr. Hill. I do have a couple of cases that are just being set for last. If you could place those on the record, Your Honor.
All right. That's your only plea for today?
I have a few potential pleas, but I'd like to get the,
Jose Lazaro Espinal.
he's gonna be a plea.
Oh, and we don't need an interpreter?
No.
Eric Rainey. There you are. This is file 25838SM. Despite Mr. Rainey's telling me he wasn't going to come back and see me anymore, he came back again on this case. It was a malicious destruction of personal property, over $200. We're going to set this for a last pretrial.
That's correct, Your Honor.
So Rainey, you owe me $468. I'm not worried about the booking fee. You got an unpaid MDOP case. You already have one of these. And some license charges. You're on payment plans. I want you to go out and check into paying on that stuff. Are you working someplace?
No.
When did you last work?
I was pressure washing, but it's a lot slow right now. But it was just been a couple weeks since I.
Well, it's ironic that one of the cases you're not paying on is a malicious destruction of property, and now you're charged with another one. So it increases the likelihood that you're going to go to jail if you get convicted of this. So it's in your interest to try to pay on this stuff. So I want you to go out to the counter. The lady will tell them what you owe, and I want you to start to pay on it. Otherwise, the matter will be set for a pretrial on a Thursday afternoon, and I'll see you at that time.
Thank you.
You're good to go. You go with the court officer. All right, Kit Carson. Good morning, sir. Are you Kit Wallace Carson?
Yes, I am. Good morning.
I met you at your arraignment. You're charged here with operating while intoxicated. Was there an impaired offer here?
There was, Your Honor, in speaking with Mr. George, the city prosecutor, he's indicated, and I received it yesterday as well. There's some video we'd both like to review. So we're asking that to be set for last.
All right. Mr. Carson, I don't believe you owe me any money, and you've always been here in a timely manner. And so I'm not worried about losing track of you, but what you need to do is stay in contact with your lawyer. She'll make an appointment. You guys sit down and watch the video together, and then you can decide whether you wish to accept the plea offer or not. If you don't want to, you can have a trial on this if you wish. And that'll be sometime later this fall.
Okay.
In the meantime, we'll set a final pretrial for Thursday at 2:00. You're good to go.
All right. Thank you, sir.
I'll send you the date and the Mr. Carson, okay? And then
In the
I'll call
mail.
you. Yep, and then I'll call you when you have.
You know, I set Luke Knopfinger for instant pretrial from a lady that was arraigned yesterday. I'm not sure that Luke is even set to be, oh no, yes, he is. He's got some cases. I haven't seen him yet. Anybody spot Luke?
I haven't seen it.
Zach Bauman? All right. You're Zachary Bauman?
Yes, sir, I am. Good morning.
Good morning. The file number here is 251172. You're charged with assault and battery, alleging to have occurred on June 12th. Prosecutors apparently made no offer other than plea as charged. So they're asking for a final pretrial, which I will set. Just like a lot of people today, Mr. Bauman, you got a bunch of unpaid fines, which may go into the prosecutor's choice to not reduce this.
He did make a payment here this morning, Your Honor. We were both in the clerk's office at the same time, so.
Yeah, I paid 80 today on it.
All right, very good. It's a lot. It's $1,600, but every little payment I'll give you credit for. If you came in and paid $10, I would acknowledge that you were paying on it.
Thank you.
All right, there's disturbing the peace, allowing another violate the motor vehicle code, no proof of insurance, and an expired license. So it's a lot of stuff, but we'll set this for a final pretrial on a Thursday. Looks like Jordan's going to be busy on an upcoming Thursday afternoon, but maybe we can resolve some of these cases at that time. Are you still at lower court?
Yes, sir.
All right, you're good to go.
Thank you, Your Honor.
Dante Williams?
He's in custody, Your Honor. Mr. Simon is my last one that's on bond. That's going to be set for last.
All right, we'll just set Dante Williams for our last pretrial.
He's set for a bond violation today too. I don't know if you wanted to have him here for that. There's going to be a denial.
All right, we'll make a record on it.
Thank you.
Matthew Simon. Good morning, sir. You Matthew William Simon?
Good morning, Your Honor. Yes, I am.
Mr. Simon, I met you at your arraignment. You have a 2-count domestic assault charge alleging that on or about May 3rd, you assaulted Danielle Collins. At this point, there are bond conditions that you're not to have any contact with her. As far as I can tell, you've been in compliance with your bond. And you're asking to set this for a final pretrial?
Yes, Your Honor.
Was there, it's just that this just says as charged.
That's
so-
correct. There was no offer from the prosecuting attorney on this case.
And from my recollection, it was from Mark. That's what I was picked up on for the warrant. That's what I was told, not May.
Well, there's two different charges.
I was unaware of May one.
Well, let's take a look. May 3rd, I was dispatched to Cato Lane. Caller report, you called police. Yeah, this all reflects May 3rd.
There's a March report in there as well. The complaint says May 3rd, so we have a lot to
Sort that
discuss
out.
on this
All right.
case, so yeah. We'll continue to do so.
All right, you're good to go. You still live in Franklin, Indiana?
Yes, Your Honor.
And there's a no contact provision, and I'm sure you've been in compliance with that.
He has, Your Honor.
I don't see that you owe me any money. But you're good to go.
Thank you, Your Honor.
Thank you. We'll talk soon, okay?
Okay, thank you.
Let's do Mr. I don't have it, Mr. Lazaro Espinal. Do you have that one?
Did I not give that to you?
If you did, I lost it.
I might not have gotten it from Luke. I kind of threw a bunch at him, so.
All right, well, let me go ask Luke for it. I don't have it. Come up and have a seat, sir. I'll get your file. No, I have it here.
Okay.
Not yet. They go in different directions. Miss Slater, I see you're here. When did you bond out? Okay, good. This is file number 25656, People versus Jose Natividad Lazaro Espinal. That's you, sir?
Yes, sir.
It's alleged that on or about March 23rd, that you assaulted someone you had a dating relationship with, Abigail Butts. That is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Do you understand the charge?
Yes, sir.
Apparently, the prosecutor is recommending that I place you on the deferred domestic assault deferral. And what that entails is a probation. And if you successfully complete the probation, the charge would be removed as a public record of conviction, and it wouldn't carry a firearm restriction. Do you understand?
Yes, sir.
Anybody threaten you to get you to plead to this charge?
No, sir.
Or promise you anything?
No, sir.
All right, well, you were in here when I went through the advice of rights here a few minutes ago. Do you understand you have those same rights?
Yes, sir.
All right, let's go back to March. Were you in a relationship with Abigail Butts?
Yes, sir.
And you'd been drinking, and tell me what happened.
Most of it's a blur. I was drinking that day. We got in an altercation, and I guess I was trying to leave, and I shouldn't have been. And then, from what I recall, after that I ended up in the backseat of a cop car.
Sounds like a bad country western song. Somebody let a fly in here. It says here you choked her and then slapped her. She didn't want to press charges, but the prosecutor did. All right. Do you acknowledge that you hit her?
Yes, sir.
All right.
Your Honor, the magistrate did not place a no contact provision on his bond conditions. I did confirm that with the order that was provided to me.
Is Ms. Butts here?
She is here.
Ms. Butts, would you come up and have a seat? People probably ask you if you have a sister named Bertha. Yes, please. One of the Butts sisters. All right, you were with Jose on this day,
Yes, sir.
and you understand how this works.
Yeah.
If he does this, I'm gonna put him on probation. He's gonna comply with the terms of probation, or he's gonna go to jail. He's gonna have to go to the anger management class. Actually, I'm gonna put him in the domestic violence class. If he successfully completes it, the charge will be removed as a public record of conviction. He can't drink any alcohol. He can't engage in any assaultive or threatening behavior, or he'll end up back in jail. So I'm gonna do no alcohol, no drugs, domestic violence treatment class, and supervision to make sure that we don't get into this. Do you understand?
Yes, sir.
Is that agreeable with you?
Yeah.
Do you and he have children together?
Yes.
How many?
I have technically 6 kids total, but the one child we have together.
And you told me this before I try to, because you're not, how old are you? Like 23?
26.
26. You have a busy house.
Yeah.
Well, Ms. Harden, I don't see any reason why I can't go write this sentence here. Prosecutors made the offer, I'm complaining witnesses here. The law requires as a rule that I adjourn these for 10 days to allow input from the complaining witness. In this case, the complaining witness is here. I gotta find a domestic violence judgment. So. So do you guys still live together on Hatch Street?
Not Half Street no more. We bought our own house.
All
It's
right.
on West Chicago Road, still in Sturgis.
Where do you work, sir?
I'm an assistant manager at Popeyes.
And you told me that too, which is where?
In Sturgis.
I didn't realize there was a Popeyes in Sturgis. Some people swear by Popeyes. How long were you in jail?
I was there for Sunday, Saturday, and Monday. I got out at 5.
All right, I'm gonna order 13 days, credit 3. Of the 13 days, 10 are deferred. So you're not gonna do any more jail time if you do what I ask you to do. I'm gonna make the fine 0 because you're gonna owe enough other stuff. And this is money away from your family. Size $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee. I'm gonna do a 12-month probation, which is $480. You could be discharged early and you're gonna pay for the class. This is pretty bad stuff. I'm gonna put the whole DV group. No assaultive or threatening behavior, no drugs, and no alcohol. That includes marijuana. Marijuana is legal for adults for recreational purposes. Are you a marijuana user?
Yeah, I am.
But you're gonna have to stop while you're on this probation. You're gonna be what we call clean and sober. And your family deserves you to get your act together. You guys got 6 kids in that household. I'm sure every day is exhausting. All right, why don't you take this form downstairs to the probation department. There's not a no contact provision, so you can be together. But I don't want any assaultive or threatening behavior and no alcohol. That may be hard. But it's all for everybody's. All right. I guess we'll just leave it at this. Ms. Butts, when did you last check in with your PO?
Yesterday.
All right, I was gonna say you
I
might.
paid everything in full too. I just have to wait now till October. That'd be
All
my
right.
last 6 months.
I was gonna have you just check in with them as long as you were here, but you're already on top of it. All right, I hope you can both do this, both get off probation, have a better circumstance than you have now. You're good to go. You go downstairs in the probation department.
Thank you,
We'll tell you
Ron.
what you need to do next. Mr. Workman, let's do yours, and then we'll take a break, and I'll take these files out. Tim, how are you doing upstairs? Are you done up there? What have you got left for me? All right, Mr. Gary's here. There he is. Well, what did I do with that file? Did you give me the, oh, here it is. I have it. Are you Michael Anthony Haida?
Yes, I am.
All right, welcome. I think I met you at your arraignment. You're from Midland, correct?
I am.
You got arrested here in St. Joseph County on July 12th for operating while intoxicated.
Yes, Your Honor.
Let's find that one. There it is. All right, you got a ticket at 1:06 a.m. South Main Forest Street in Three Rivers at the south end of town. They allege that you were intoxicated. You're driving a 2003 Volkswagen. It appears the prosecutors agreed to reduce this to a charge of impaired driving. Impaired driving is a lesser included offense of operating while intoxicated. Operating while intoxicated, what people normally refer to as drunk driving, is a misdemeanor. It's punishable by up to 93 days in jail, fine of up to $500, and it requires that your license be suspended. Also carries 6 points. Impaired driving is a lesser included charge. Carries a maximum fine of $300, carries 4 points, and most importantly, would allow you to keep a restricted driver's license to drive back and forth to work. And I'm sure that's important to you. Mr. Workman, that's your understanding of the plea agreement?
It is, Your Honor.
Were you driving a car about 1 o'clock in the morning on July 12th?
Yes, Your Honor.
Where were you going?
I was going to the hotel after my friend's wedding.
All right. Where was the wedding reception?
The wedding reception was in Marcellus. Yeah, a small wedding venue.
All right. You must have got lost. Where was the hotel?
The hotel, I believe, was in Three Rivers.
All right. That's how you happen to be down here in St. Joe County?
Yes, Your Honor.
That happens more often than you think. I was at a wedding reception and a man from outside the area was there at the wedding. And he was drunk. And I was talking to him, boy, that guy's drunk. He thought he was going to stay there. And the people that were hosting didn't want him to stay there because he was so drunk. So he left and was on his way to Three Rivers to a hotel. And he got arrested. I think maybe he went off the road. So he came in here and it was the same guy. I said, well, I can't be the judge. And I saw you, you were drunk. I would be a witness against you. So Judge Pattison handled the case. Who was the friend that got married?
My best friend, Connor Fleming.
Okay. What were you drinking?
I was drinking screwdrivers that night.
And what was the blood alcohol?
0.158.
That'll do it. That's 2 times the legal limit. It doesn't sound like you make a habit of this. We get several hundred drunk driving cases a year. They come in different varieties. Some people get repeat offenses. Some people get one and it lasts a lifetime. It's embarrassing, it's expensive, it's cumbersome, and it was just bad judgment. Did you have anybody in the car with you?
I did not, Your Honor.
Well, you weren't going toward the hotel. I think you got sideways somewhere on Main Street and you overshot probably Broadway, which would have taken you back out to the hotel. Did you know where you were going?
I was just following my friends, Your Honor.
All right. Well, maybe they were lost because this ain't on the way to there.
Quite possible.
Now, you got a lot of points on your license. You got some tickets driving back to the future in some other jurisdictions. This would allow you to keep a restricted license, but if you have too many points, it could suspend you for points. Do you know what your point status is right now?
I believe I have 3 points on my license.
All right, then you should be all right. What do you do?
In the summertime, I work for the DNR at Grand Haven State Park. We just wrapped that up for the season, so I'm going to be doing something else for the winter now.
All right. Well, the law requires that I set this for screening and sentencing, which means you get one more free trip to Centerville. there's a barn out there off M40 near Marcellus, which is a very nice venue. Is that where this was?
It was a barn venue, yes.
Well, let's pick a date that works for you and for Mr. Workman. Oops. Mr. Workman, how's Monday, October 6th at 11 for you?
And what time did you say that would be?
11 a.m.
I'm showing, I have a sentencing in Kalamazoo at 8:30 a.m.
So you should be able to make it here by then?
Yeah.
All right, I hope so.
As long as the construction doesn't start back up.
Set for sentence 10/6/25 at 8:30. All right, sir, I think this might be the kind of thing that this might last you a lifetime. It's, you came for the wedding, you came for your arraignment, you came for the pretrial, and you're going to come for the sentence. About almost 4 hours from here to Midland. But we'll have one more date, October 6th. I want you to take this out to the counter and we'll give you a time and date to come in for your screening and sentencing. All right, I'm gonna take some of these files out. Don't go away. We'll be back in about a minute. Also, I'll see if anybody brought in cookies.
Judge will give you 5 minutes.
All right, yeah, it might take me a couple minutes if there's a cookie. And I'll take a look at what I've got here, because I've got about 12 or more cases up here. I think.
Notice that
In Constantine? They got a new chief down there. All right, I'll be back in a minute.
Yeah. Our voicemail's great. It's great.
The transcript.
Cookies.
No.
All right, Mr. George, Mr. Espinal Lazaro called and he wanted to know if he could reset. Jordan indicated she had had the case. It got deferred to you.
Mr. Rios.
Yeah, Rios.
Okay.
Yeah, and I think he needs an interpreter and you'd have to, he was willing to come, but you don't know anything about it yet. It might be safer. So Lapita, if you can hear me, go ahead and reschedule Mr. Reyes Rios.
Can I give this to you right now, Judge?
Yes.
This is the paperwork for it. I can look at her reports.
Mr. Fair, why don't you come up and have a seat? Well, I'll just do a last pre-trial. This is two matters regarding Peter James Fair. I had these as for Miss Ives, but Mr. Truckee apparently has the cases. Charges no insurance and another misdemeanor charge of and then there's another charge of registration. So there's three total things. Mr. Truckee advised those matters have been resolved with a civil infraction offer.
Yes, there'll be one civil infraction with the state, and one in a city of Sturgis case, and the other city of Sturgis case with the Smiths.
Mr. Fair is my cousin, but I don't have a problem handling this. Peter, do you? His grandfather was my first cousin, which makes him a first cousin twice removed, I think.
It's a family haircut.
His looks better than mine. All right, Mr. Truckee's got to be in Three Rivers. Why don't you take Peter out to the counter? They can deal with these civil infractions and you're good to go.
Thank you, Your Honor.
Well, it wasn't his grandfather, it was his father. Let me give you this. He's my first cousin once removed.
Yeah,
All right, so where were we? Mr. George, let's see if we can.
Mr. Whiteberg, he's just a pleaded driving suspended.
Let's take care of that.
Okay. And then Mr. Gary's our last, and I have one more show.
All right.
That's listed. This is Mr.
Yes, is Mr. Dot here?
He's in custody.
Oh, he's at the jail. Yeah, we said we'd do him by Zoom. All right. Okay. We got miles to go before we sleep. Good morning, sir. Are you Clinton Joseph Whiteberg?
Wiedeberg. Yes, Your Honor.
You got charged with driving suspended. Improper plate, those often go together, and refusing a preliminary breath test. Refusing a preliminary breath test, a civil infraction, costs $165. Prosecutors agreed to dismiss that charge. They've also agreed to dismiss the improper plate, which is going to save you all at least $100. And you're going to plead to driving with a suspended license. Is that correct?
Yes, Your Honor.
Anybody threaten you to get you to do that
No, Your Honor.
or promise you anything?
No.
Driving suspended and its related charges are our most common offense. No ops, no valid ops ever acquired. And driving suspended. They're all kind of related. People are not driving without authorization. Let's take a look at your circumstance. You got this ticket at 11:51 in the morning, Nottawa and Wassippi Road, kind of out in Amish territory. Where were you going?
Well, I was driving a vehicle because the people at the 4th of July party weren't able to drive, and I had a bunch of wagons and everything in the back from the lake party, and some kids were tailgating me, and they drove around me and they threw a beer bottle and smashed into my windshield. So I went from Sprinkle Road to there.
Well, you weren't supposed to be driving. You've been suspended for a long time, but you haven't had anything in a while. And you wouldn't take a breath test. So that lucky they didn't do more than that. And they're dismissing that.
That's understandable. It's lucky on that.
All right, sir. What do you do now?
I climb trees for a company, bulkhead operator.
Well, there's a presumption there'll be a fine only, and that's what I'm gonna do here, $125 fine, $75 crime victims' rights fee, a $50 state minimum fee, and $150 attorney fee. That's $400. 250 plus 150 is $400. They dismissed about $300 worth of stuff. Can you pay that within 30 days?
Yes.
10/5/25. You can pay it today if you want, but I'll give you an envelope. You can send in green. Well, don't send in cash. You can send in a certified check or money order, bring in cash, or pay with a credit card. The instructions are inside. All right, you're good to go, sir. Who are your no-shows?
I have Mr. Montgomery. And then we already addressed Mr. Rios.
All right. What's Mr. Geary gonna do?
We're just gonna set this for a final pretrial, Your Honor.
All right. Good morning. You're Daniel Geary.
Good morning, Judge. Sorry,
Judge. I'll answer to that. We're going to set this for a final pretrial and see whether the matter can be resolved. The charge is domestic violence, interfering with a crime report. Are you still living down in Constantine?
Not with my mom and dad right now.
You're back. Are you in Cole or you're in Constantine?
I'm with my parents still, waiting to okay to, yeah, because we're getting ready to sell the house here in a couple of weeks to, I'm trying to help her change a few places and things. She needs to have a fresh start. So, just 2 weeks, our house will be going up for sale on top.
Okay.
Anyways, just got finished the room up on the remodel. And,
well, I don't see that you owe me any money.
Am I even with you? I was going to ask you on that because I knew I owed you.
I thought you did.
$1,200 or something like that.
I don't see it.
But I actually paid $50 yesterday.
All right.
When I got.
Oh, there it is. You owe me $209. You got an unpaid disturbing the peace. You paid $50 yesterday.
Yeah.
All right, we'll set a final pretrial. You know how to get a hold of your lawyer. He's represented you before in some other matters.
Is it, before you make final judgment, is it okay that I can go over there and
finish what?
Floor remodel of the house? Because you told us not to, unless you want to drop that so we can be, within 50 feet of each other or something,
No, not till we've resolved this.
Okay. So I'll just have to wait then. I mean,
yes, you will.
When she's gone or whatever.
Okay. All right. Thank you.
Thank you.
Okay, sir.
And then our no-show is Anthony Montgomery. He's charged with driving suspended. I think he may have a previous no-show.
I believe that's correct.
Bench warrant, $400 cash or surety of 48-hour notice. That finishes Mr. George. Rhonda, you're gonna be here for a while because we're gonna need to do the other cases. Anybody seen Luke Knopfinger? Because he had some cases set for this morning. Joshua Brown, Lori Allen, Mark Wittenberg. And then I set an instant one for him. Oh, thanks. Paul, let's take a look at what you've got for me. Oh, because I set that instant one, that girl's in jail. But Luke had about 5 cases on here.
I don't see. That's the only stupid order during my seat.
All right, hold it, I gave you that, I need that. Good morning. What's your name?
Alexis Emerson.
Is Kenneth Stokes here? All right, another for Miss Harden.
Kenneth Stokes, right?
Yep.
All rise.
We are still on the record. Anything that is said back there in the gallery is getting recorded, by the way. I'm just saying, so you guys do know. All right, never mind.
Wake everybody up. When we find Jordan, Mr. Stokes. All right.
$162. Do you know where Jordan Hopkins is? You believe that she is in a conference room like the second.
All right, well, she's still here. What?
It's already.
Okay, very good. There's a lot of cases in here. Here it is. This is file number 251278, People versus Alexis Page Emerson. That's you?
Yes, Your Honor.
You got charged with driving suspended. which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Prosecutors agreed to reduce this to a civil infraction charge of impeding traffic. That carries a $100 fine. Is that your understanding, Mr. Gibson?
Yes, Your Honor.
Ms. Emerson, did you get your license back?
Yes, Your Honor.
Very good. This one doesn't carry any points and it won't affect your license, but it is a civil infraction.
She has she has a temporary operator's license at this point.
All right, well, we got to start somewhere. All right, fine and cost is $100. You pay that by October 5th.
Yes, Your Honor.
Did you not have a valid license at that time?
I had the restricted license that I applied for from my previous.
But you didn't have an adult driver in the car with you?
No, Your Honor.
All right, that'll be enough for impeding. All right, good luck to you. This should not affect your ability to keep your license. Good luck with your driver test. And you're good to go.
Thank you, Your Honor. Thank you.
Mr. Montgomery? He's not here. Well, Rhonda, it looks like got some of your cases. That's George.
Where would you like to begin? Monica Dean is in lockup, but they wanted to get her back to the jail.
Yeah, why don't you bring her? Let's deal with Mr. Stokes, Jordan.
I can see her. Okay.
This is a domestic violence charge. The complaining witness, I believe, is Mr. Stokes's stepsister, Brenda Garn. Mr. Stokes, you live in Marcellus, right? You live on Finch Road in Marcellus? You're charged with domestic assault. It's alleged that you assaulted Brenda Garn. She also asked for a personal protection order against you, and that order has been served this morning. You got it there in your hand. So you're not to have any contact with her. We'll set a final pretrial on a Thursday afternoon.
I'm having a hard time.
All right.
Can you hear? Can you hear?
Yeah, well.
Okay.
All right, Mr. Stokes.
Whoa.
Not that bad.
I guess you can hear me now.
Oh,
Okay. That blew your hair back. All right, are you Kenneth Edward Stokes?
Yes, sir.
All right. They served you with a personal protection order this morning on this matter. The complainant, Brenda Garn, I think is your stepsister?
Half sister.
Half sister?
Supposedly, I don't. That's.
All right. Well, anyway, you're not to have any contact with her pending this disposition. You stay out in Marcellus. She'll stay where she is. I don't want you to have any contact with her. We're going to set this for a pretrial conference on a day to be determined.
So can I still get the rest of my stuff that's out of her house?
You'll have to send an agent or somebody to do it.
All right.
You can't go there, but you can ask someone to retrieve it for you.
All right, thank you.
All right, you're good to go.
Thank you.
Now, don't just show up at her door, make arrangements to get your stuff.
Could you repeat that, Your Honor?
Uh,
I took them off for a second.
all right, don't just have somebody show up and pound on her door. Make arrangements for whoever you're gonna use as your intermediary to go get this stuff.
Okay.
All right, you're good to go.
Thank you.
Does that finish your obligations, Jordan?
No. You just want to check out on the counter for the report. I'll help you with that, okay?
Okay.
Oh, we gotta deal with Dante Williams. but we
I've got several in custodies and then Miss Nickerson did appear, so,
All right,
but Rhonda's been waiting, so.
all right. we'll
I've got a
address
bunch
it.
of-
Yes.
I do. I'm all done with it. You can go.
What about that?
You can do that yourself. I don't do that. Okay.
I guess.
Rhonda, I don't have that.
She has another pending file that's a domestic violence scheduled for sentencing with Judge Pattison that I am on October 9th. In discussing the case with her, she indicated that if she were to be released, she would appear for sentencing as the court directs. Or perhaps the court may want to sentence her today. I think we've got a question though of restitution.
At the jail, can you unmute your device?
Unmute.
All right. What is your name, sir?
James Benner. How in the world do I get that screen bigger?
You know what page?
Hey, funny, good to see your face.
Mr. Benner, you're here to be arraigned on a charge of probation violation, violation of community corrections, actually. You have the right to an attorney to represent you. Would you like to have a lawyer appointed to represent you?
Yes, sir.
Public defender will be appointed.
Your Honor, I acknowledge receiving a copy of the petition and waive formal reading of the same on behalf of the defendant, enter a plea of not guilty.
Plea not guilty is entered. You want to set this for hearing later this month?
Yes, sir, please.
That would be on, looking at October 29th of September.
Yes, sir.
Your lawyer will be up to talk with you and get you ready for a hearing on our disposition on September the 29th.
All right, thank you.
Good
morning.
What's your name, please?
Warren Esteban Brooks.
Mr. Brooks, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
You were my elbow counsel last time, Judge. We went cross-eyed. I was supposed to have an update in September. I've been running the diner down there at Shoney's. And I went to Natchez Trace and I got on ADD medicine. I have a prescription for sulfameth, SULFAMETH. And I got wary that when I reported to my probation officer, I got wary, Pop. That's all it was. I got wary. But I got clean toxins and I got check stubs. I got a clean record. I just need to be reinstated, Pop. They got me on 8/31 and they got me on 8/30 after the beauty pageant. Me and my daughter, we won the beauty pageant down there. And we won the beauty pageant and she came in first place and I was walking home and I've lost my job at Shoney's. Mr. Dan, he's the man, he's the owner. I've been here for 4 days, Pop. Mr. Wolf, I just need to be reinstated. I can piss in the cup. I just need to go home, Mr. Wolf. I'm running the diner down there. I'm a dishwasher down there in Shoney's. Please, Mr. Wolf. Please,
I'm going to appoint a public defender to represent you so that they can help you with what you're saying is taking place.
Yes, sir.
And I'm going to give them a copy of the charges and enter a plea of not guilty. And then the public defender will talk with you, and if they can establish what you're saying as far as the reason that you may have
Yes,
testified,
sir.
then we'll go from there.
Thank you so much, Judge Wolf. I just got to talk to Mr. Dan and get my job back. I run that back. I'm down there at Shoney's, Mr. Dan. You come on down there and see us.
Well, I want you to understand the public defender is going to be there to represent you. So let them help you with your defense, and we'll see how we can get this worked out. All right.
Thank you so much, Judge Wolf. I love you, family.
Will that be on September 29, Your Honor?
September 29.
Yes, sir.
Amen. Amen. Thank you, Judge Wolf. I damn it. Oh, thank you, Jesus. September 29.
Well, his daughter won the pageant that he was talking about. So, okay.
I'm about to start crying.
Always nice to have satisfaction.
Hi.
Good morning. What is your name, please?
Joshua Christian.
Mr. Christian, you're here to be arraigned on a charge of probation violation. You have the right to an attorney to represent you. Would you like to have a lawyer?
No, sir.
You do not want a lawyer?
No.
All right. I want to make sure you understand what you're charged with. It is alleged that you were placed on probation on or about the 14th day of July of this year for driving under the influence of an intoxicant, first offense, reckless endangerment, and felony reckless endangerment by a vehicle. And you were sentenced to a probation for a period of 1 year. It is alleged that you have violated that by violation of Rule 8, because on July 17, 2025, you submitted to a drug screen using a 13-panel urinalysis test, and you tested positive for fentanyl and MDMA. On July 25th, the results were confirmed by Alaire Toxicology Services. So that is what the charge is, and if you are found guilty of that, then you're facing the revocation of your sentence of 1 year. You would have to serve that in prison. So I ask you again, do you now wish to have a lawyer represent you on this matter?
I imagine I would then.
I don't blame you. Public defender will be appointed.
May I speak? Say one last thing?
I'm sorry?
The drug test was given to me less than 72 hours after I pleaded guilty. I don't know if that matters any, but I didn't have any time to clean.
That's the thing you need to explain to your lawyer and let him, Mr. Talbot's here with the public defender's office. He will come and talk with you about it, and we'll let you know what the possible defenses might be to this drug test situation. So I'm going to appoint the public defender and enter a plea of not guilty and set it for September 29th.
Yes, sir.
He'll be up to talk with you and see what that can work out.
All right.
Thank you.
Thank you.
Oh, Timothy, I'm sorry. Just have some.
Good morning. What is your name, please?
Mr. Dawson.
Mr. Dawson, you're here on an indictment charging you with possession of methamphetamine with intent to deliver over 0.5 grams, simple possession of a Schedule 1 drug, simple possession of a Schedule 2 drug, simple possession of a Schedule 6 drug, and unlawful drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer represent you?
I've already been to court. I've already had an attorney appointed. Also.
All right, was it the
I've had
public?
a preliminary hearing. I've already had a preliminary hearing and everything on all this.
Oh, sir, I represented Mr. Dawson in the
All right.
preliminary hearing and general
The
session.
lawyer that you previously had is here, and I'm appointing him to represent you. He's with the public defender's office. So
Yes, sir.
we'll.
Thank you.
And Your Honor, I acknowledge receiving a copy of the indictment. I waive formal reading of the same. On behalf of Mr. Dawson, I enter a plea of not guilty.
Plea of not guilty is entered. Do we want to set this for a status day, or how do you want to handle it, gentlemen? January 7th. All right, January 7th for status. What that means is that your lawyer is going to come talk with you, get you up to date on what the status is and what the evidence is against you, and we'll see you on January the 7th. If you're able to resolve it, then we'll let you dispose of the case by an agreement. If not, then we'll set you a trial date. All right?
Okay, Your Honor, I got one question. I've got a court date for September the 29th.
That's a
And
violation of probation, and I don't have that one on my docket, but that will likely be continued until after this January 7th date.
okay, that's what I couldn't understand. I thought they had them all the same day.
Right.
Okay. All right, thank you, sir. Thank you. Is that all?
You're fine. Yeah, we're done with you. They'll be up to talk with you. Thank you.
Thank you, sir.
Good morning. What is your name, please?
Chaz Green.
Page 6. Green, you're here to be arraigned on a charge of aggravated domestic assault in one indictment. Another indictment is charging you with possession of a weapon by a convicted felon and knowingly violating a condition of release, as well as a violation of conditional release. You have a multi-count indictment. And as a result of that, you have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
Yeah, I should have Odom.
Did you have a lawyer in the lower court appointed for you?
Yes, sir. I had Mr. Odom.
Mark Odell?
Yes, sir.
All right. Well, we're going to go ahead and appoint Mr. Odell to represent you as well. And let's stand in for Mr. Odell, if you will, Mr. Talbot.
Standing in for Mr. Odell, I acknowledge receipt of a copy of the indictment and waive formal reading of the same on behalf of the defendant. Enter a plea of not guilty.
Plea of not guilty is entered. This is General Sylvie's case. Do we know if she wants to set a trial date? And General Sylvie, you're here. Just didn't see you in the back. They're looking for those dates, I think. Is that a trial date or a status date? So the December 1st is a status day? And
We
that's,
could set it for a status with that as well.
all right. Mr. Green, we're going to put these new cases with some that are already pending on December the 1st, so that these will also be set for that day to let your lawyer work on these cases as well as the other cases. So a plea of not guilty is entered, and Mr. Odell will be given a copy of these charges, and he'll be up to talk with you as quickly as he can.
Okay, yes, sir. And then is there any way about the bond source hearing or anything?
Mr. Odell will have to file a motion for a bond and then we can deal with it at an appropriate time.
Okay, yes, sir.
All right. Thank you.
Thank you.
Good morning. What is your name?
LaMarcus Jackson.
Mr. Jackson. Jackson is on page 7. Public defender represents Mr. Jackson.
Yes, sir. And we'd already been appointed for a VOP on 10/20. I understand this is an amendment he needs to be arraigned on.
This is an arraignment on an amended violation of probation, and the original one is set for October the 20th, so we'll leave this one.
Could we move it up to this month, Your Honor? I think we can probably get it resolved.
That's fine. We'll show the public defender is appointed to represent the defendant on this new amended charge, and we'll set it for hearing on September the 29th.
Thank you, sir.
All right.
Thank you.
Good morning. What is your name, please?
Garrett Jones.
All right, Mr. Jones, you're here to be arraigned on an indictment charging you with possession of methamphetamine and of 20.26 grams or more, and also possession of manufacturing or delivery or sale or conspiracy to do that of certain drugs, and money laundering. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public defender?
Yes, sir.
Thank you, Madam Clerk. Your Honor, I acknowledge receipt of a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Now, there are three co-defendants, is that correct? Any idea of whether or not that presents an issue for you?
No, sir, no.
All right, we'll leave you in the case until then. All right, General Stevenson, you wish to let me know how you want to handle the scheduling of this? January 7th. All right, January 7th for status. Public defender's been appointed you to represent you, Mr. Jones, and they'll be up to talk with you and get you ready for either a disposition on your case in January or we'll assign a trial date. Thank you.
Thank you.
Good morning. What is your name, please?
Ronnie McCoy. Judge,
Sir?
I've been here almost 3 years and I've never seen the evidence the state has against me or anything else. I don't know. Matthew Bruner was my attorney and he withdrew, and now I've had, since February, I've had three different attorneys that's had conflict or whatever. But I still have yet to see what the state has against me.
All right, Mr. McCoy, the problem that we have is that you're one of a number of defendants that were all on a conspiracy count, and I think there were like 27 defendants that were charged in one indictment. That presents ethical problems for lawyers to represent more than one of these individuals. And I understand that you've been awaiting trial for a long period of time. And the problem is that we keep appointing attorneys who, for whatever reason, have to withdraw. For example, the attorney that we appointed the last go round, an attorney named Vid Sanker, has now surrendered his law license. He is no longer practicing. And as a result of that, I've got to find another attorney for you. Let's bring Mr. McCoy over at 1 o'clock for me to, and I'm going to find you a lawyer, and we're going to deal with your situation as quickly as we can to try to get something done one way or the other in your case. So we'll bring you over here at 1 o'clock, and I'll see what I can find out between now and then, okay?
Okay. Thank you. No, I can't see none of y'all.
Good morning. What is your name, please?
Randall Robinson.
Page 13 and 14. All right, Mr. Robinson, you're here to be arraigned on an indictment charging you with violation of the sex offender registry form and violation of community supervision. In one indictment, you're also charged with resisting a stop, arrest, and search and evading arrest in a separate indictment. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, then I'll appoint the public defender to represent you.
Yes, sir. I acknowledge receipt of a copy of the indictments and waive formal reading of the same on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson. All right, be set for status on January the 7th. We're setting it for January the 7th of 2026 for you to dispose of your case by an agreement, or we'll assign a trial date on that day if you've not been able to arrive at an agreement. If you get something worked out with your lawyer, then it can be taken up earlier than that on a different court date. But right now, that's where we're setting it.
And what's my attorney's name, sir?
My name is Zachary Talbot. I'm with the Public Defender's Office.
Okay. Good.
All right, thank you. Morning, what is your name, please?
Walter Whitmore.
On page 18. Mr. Whitmore, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
No, sir.
No?
No.
All right. Let me arraign you on this charge. You are charged with having been placed on probation on or about the 25th day of February 2014 for the offense of promotion of manufacturing of methamphetamine, and that you were sentenced to 2 years, and that you had allegedly violated your probation by violation of Rule 5 in that on or about January the 15th of 2015, you had been kicked out of your last reported residence and had not contacted your probation officer to update your address. And for that reason, there was a violation of probation warrant that was issued. It's also alleged that you last reported to probation December the 22nd, 2014, and failed to report for the month of January 2015. And you also have not paid your supervisory fees or your court costs. Now, I'm not sure of exactly what the circumstances were in this case, but because of the fact that this is a case that's pending since 2015, I'm going to appoint the public defender to represent you because there's an issue that's come up with some appellate court decisions that I think you need to make sure that you get the benefit of legal expertise to raise any issues that might exist.
All right.
Public defender will be appointed. We'll set it for September the 29th. plea of not guilty is entered.
Yes, sir.
I understand you. I know you're well aware of the issue that I'm concerned about. So.
Yeah.
All right, September 29th.
Thank you.
Good morning. What is your name, please?
Ladera Williams.
Mr. Williams, you're here to be arraigned on an indictment charging you with theft of property, simple possession of methamphetamine, and possession of drug paraphernalia. You have the right to an attorney. Do you wish to have a lawyer?
Present today or just in general?
I'm sorry, you want to have a lawyer appointed for you?
For now, yes, sir.
All right. Public defender will be appointed. Sorry.
Your Honor, I acknowledge receiving a copy of the indictment, waive formal reading of the same, and not guilty on behalf of the defendant.
All right. Status day, January 7th, General. Except for status on January the 7th of 2026. What that means is that we're going to give your lawyer time to work on the resolution of your case. If it's able to be resolved by an agreement, then we'll take it up either before or on January the 7th. And on January the 7th, if it's not resolved, we will assign a trial date. Thank you.
Is that it?
Yep, they'll be up to talk with you and try to get you ready for disposition or trial.
Thank you, sir.
All right, thank you.
Hey, Mom. Hey, Deputy Dawson, could you put my Alpha One out, please? And then I need you to escort Inspector Delphi, if you don't mind.
All right, well, let's mute him and we'll go on and take up the regular docket as well. We'll start down through the regular docket until we're able to get some more inmates brought in. On page 3, 2025 CR 210, State versus Corey James Cameron. Mr. Cameron here. Let's all look around and see. Anybody see Corey James Cameron?
I believe he's an inmate, Your Honor.
We don't have him in jail, so I guess that would explain why we're looking around for him. Do we not have him in jail? All right, well, let's see who we got at the jail. I need you to unmute the jail's video, please. I need you to unmute the jail video, please. There you go. Good morning. What is your name?
Chris King.
King, you're here to be arraigned on an indictment charging you with aggravated burglary of a habitation, theft of property, falsely representing yourself as a lawyer. That's interesting. And financial exploitation of an elderly or vulnerable person and criminal impersonation. You represented, well, I don't want to ask you any questions, but the indictment on count 3 states that the grand jurors aforesaid upon their oaths aforesaid do further present and say that on or about July 30th, 2025, and prior to the finding of this indictment in the county and state aforesaid that said Christopher Lane King and Amanda M. Roberts then and there did unlawfully, feloniously, directly or indirectly, falsely represent themselves as a lawyer to wit, Roger Wainick, in violation of TCA 23-3-108, Class C felony, all of which is against the peace and dignity. That's the first time I've ever seen, and I'm not even going to say how many years I've been in the legal profession, but I've never seen that charge. In any event, you have the right to an attorney, an actual attorney, Mr. King. Would you like to have an actual attorney represent you?
Yes, sir.
Do we want to appoint Mr. Wainick to represent him? Are you wanting to be appointed? All right. Does the public defender have any reason that you couldn't represent this defendant? You would have a conflict. This is the, what's wrong with my hand scribble list? Mr. Atchison, you're first on the list. Do you know of a reason you couldn't represent this defendant? All right. Mr. King, I'm going to appoint Mark Atchison, who's an accomplished and skilled litigator in his own right, and we will appoint him to represent you.
Judge, I'd acknowledge receipt of the indictment, waive formal reading, and enter a plea of not guilty at this time.
Plea of not guilty is entered. We want to set this for status on January the 7th. All right, we've set it for status on January the 7th of 2026. And your lawyer will be up to talk with you and see if he can get you ready either for a resolution by an agreement, or we'll set you a trial date on January the 7th, 2026. Thank you.
Thank you, Judge.
Good morning. What is your name, please?
Eckford Jefferson.
Mr. Eckford, you are here today to be arraigned on a charge of violation of probation. You have the right to an attorney to represent you. Do you want a lawyer?
Yes, sir.
Public Defender's Office will be appointed.
Acknowledge receiving a copy of the petition, waive formal reading of the same, and enter on behalf of the defendant a plea of not guilty.
Plea of not guilty is entered, set for hearing on September 29th.
Sir.
Lawyer will be up to talk with you and get you ready for a hearing on September the 29th. Thank you.
Thank you. Have a good day.
You go at the very end of the line, all of you come next.
Good morning. What is your name?
Kenneth Oz, Mr. Wolf.
Dog, you're here to be arraigned on a charge of violation of probation. You have the right to an attorney. Do you wish to have a lawyer represent you?
I can't afford one.
Okay. Do you have some other charges? Are those still pending, and do you have a lawyer on those charges?
Only charges I know I have was in general sessions, but it was all taken care of.
Well, I'm going to appoint the public defender to represent you since you're in jail.
Yes, sir.
Yes, Your Honor. I acknowledge receiving a copy of the petition of the warrant and a waive formal reading of the same, and enter on behalf of the defendant a plea of not guilty.
Plea of not guilty is entered. Do you want to set this for the September 29th day?
Please, Your Honor.
All right, September 29th. Public defender will be up to talk with you and get you ready for a hearing on that day.
Thank you, Your Honor.
Thank you. Good morning. What is your name, please?
Raymond Perez.
Page 13. Mr. Perez, you're here today to be arraigned on a charge of possession of Schedule 6 drugs, possession of a firearm with intent to go armed during a dangerous felony, possession of unlawful drug paraphernalia, violation of a no contact order, and possession of a firearm, and possession of a controlled substance. You have the right to an attorney. Do you wish to have a lawyer?
If I get one appointed to me.
Yes. Public Defender's Office is here. They'll be appointed to represent you.
Yes, Judge. I acknowledge receipt of a copy of the indictment, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson, you want that January 7th date? We're going to set you for status on January the 7th. If your case can be resolved either before then or by then. If not, we will give you a trial date on January the 7th. Your lawyer will be up to try to talk with you and get you ready for a disposition or for a trial. Thank you.
Yes, sir. Is there a way I can get a bond reduction?
Well, I'm going to let your lawyer talk to you. This is the beginning of our month in September, so your lawyer can talk with you about the bond issue, and if there needs to be a bond reduction or a bond motion, then they can file it for you, and then we'll set you for a hearing, okay?
Yes, sir.
All right, so they'll be up to talk with you about all those things.
Yes, sir.
All right, thank you. Good morning. What is your name?
Kevin Spicer.
Kevin Spicer's on page 15. Mr. Spicer, you're here to be arraigned on a charge of probation violation. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
Public Defender's Office is here and they will be appointed to represent you.
Your Honor, I acknowledge receiving a copy of the warrant, waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. We'll set you for hearing on September the 29th. Public Defender's Office has several attorneys. One of them will be up to talk with you about your case and get you ready for a hearing on September the 29th, okay?
Sir.
Thank you.
Thank you.
All right, who's next?
Good morning. What is your name, please?
Tom Stewart.
Mr. Stewart, you're here to be arraigned on an indictment charging you with theft of property with a value of $10,000 to $60,000, a Class C felony. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
And the Public Defender's Office is here. They will be appointed to represent you. All right, Public Defender's Office has a conflict, so we will appoint Mr. Nathan Brown, who is not here at the moment, but I don't think.
What's the conflict?
Conflict is that they may represent one of the other defendants, or they may have represented one of the victims in the case or had some conflict in that way. They're not necessarily required to tell me what their conflict is, but the Code of Professional Responsibility requires them to advise me if they have a conflict that would prevent them from being able to ethically represent you. For example, you want a lawyer whose only concern is your best interest. You don't want a lawyer who's torn between whether this is going to benefit you or their other client. That's the whole idea behind a conflict of interest. So we're going to appoint Mr. Nathan Brown, who does not have that conflict. And standing in for Mr. Brown, would you, Mr. Talbot, please, for the indictment, for the arraignment?
Thank you, Your Honor. I acknowledge receiving a copy of the indictment, waive formal reading of the same, and on behalf of the defendant and on his attorney, enter a plea of not guilty.
All right. Plea of not guilty is entered. General Wojnarowski, we're going to set this for January the 7th of 2026. Mr. Brown's going to be given a copy of these charges. He'll be up to talk with you as soon as he can arrange it and get you ready for either a disposition by an agreement at some point, or if you cannot resolve it by an agreement, then on January the 7th, I will set you a trial date.
All right.
All right, thank you. He'll be up to talk with you as soon as he can. Good morning. What is your name?
William Stout.
Mr. Stout, you're here today to be arraigned on a charge of possession with intent of more than 0.5 grams of a Schedule I drug and cocaine, as well as fentanyl and drug paraphernalia. Count one is methamphetamine, more than 0.5 grams. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, please.
All right. Does the public defender know of any conflict you would have in this case? All right. Public defender has a conflict. We will appoint Mr. Jacob Finley of the Clarksville Bar, Montgomery County Bar. He'll be notified of his appointment and be in to talk with you. You wish to stand in for him for arraignment?
Yes, sir.
Hand that to him.
Your Honor, I acknowledge receiving a copy of the indictment and waive formal reading of the same, and on behalf of the defendant and his attorney, enter a plea of not guilty.
Plea of not guilty is entered. We'll set it for status on January the 7th. That means your lawyer will be up to talk with you and see if he can get you, we have to advise him of his appointment, and then he will may need to make arrangements to come talk with you. And then once he has been able to talk with you, we will see if it's able to be resolved by an agreement. If not, on January the 7th of 2026, I will set you a trial date. So they'll be up to talk with you.
All right, thanks, sir.
Good morning. What is your name?
Larry Tanksley.
Larry Tanksley. Mr. Tanksley will be arraigned on a charge of assault with bodily injury and theft. You have a lawyer named Roger Wainick that represents you. Is that correct?
Yes, sir.
All right. Mr. Wainick, has he filed a waiver? All right. Mr. Wainick is apparently in transit somewhere, so we'll allow that. Let's go ahead and stand in for arraignment. Since you have a lawyer, do you wish to have a formal reading of this indictment?
No, sir.
All right. Standing in for Mr. Wainick, the Public Defender's Office has waived the formal reading of the indictment, entered a plea of not guilty. General Sylvie, how do you wish to handle this scheduling?
Your Honor, if you want to go ahead and set it for a trial date.
All right. You want to set it for trial in January?
We'll go ahead and do that. That'll give Mr. Wayne a discovery. Do that, so we can set it for trial in January with.
Well, that judge in January may not agree to that because of the fact that's contrary to his scheduling order.
Well,
I don't know. Yeah, he can be difficult to get along with sometimes, and I've heard so. Do you,
I defer to the court then.
No.
Said it how.
to stay consistent with it, then we'll set it for January the 7th for status. And if you don't resolve it on that day, we'll give you a trial date. So
Okay.
many days as we might have in January, we might be able to even try it in January, but I'd rather just put it for status right now. My rule is that, as you know, under this new process that I'm following, once we set it for trial, it goes to trial or they plead to the indictment and go to sentencing. So that's why I don't want to set it for trial in front of me unless.
That status date will be.
Right. Thank you. I know you want to stay on good terms with that judge anyway, so. Mr. Tanksley, your lawyer will be advised of the fact that we're setting you for January we just lost the jail, so. While we're trying to get the reclaim the jails video, I'll go back to calling the regular docket. So, do we ever find out whether or not Mr. Cameron is 1 o'clock? All right. 2025 CR 77 State versus William Grant Darden. All right, I'll put it on the second call. (2023) CR 336 State versus Gregory Arnie Hansard III.
That is the state's motion to continue, Your Honor, and then we also have a 412 hearing set for today.
So the motion to continue, is there any opposition to the motion?
No, sir.
All right, do we need to go ahead and schedule for this month the 412 motion?
I've spoken.
Is this the one where she
just had the baby?
Okay.
Yes, sir. She stated that she's comfortable moving forward this afternoon with the 412, but for the trial, I think testifying about the actual event, she could not do. So we could do the 412 if the court would like to hear that today. I understand. It was motion to continue the trial, I think specifically.
There's a lawyer's, when a lawyer comes in from a hard day in court and he sits behind his desk, and then his secretary comes in and says, do you want to talk to so-and-so client on the phone? I always used to say, that's the wrong question. Not do I want to talk to that person, but will I talk to that person? So when you ask me, do I want to do the 412 motion? It is not a question of whether I want to do the 412 motion. It's a question of whether I will do it.
Yes, sir.
We have another sentencing hearing that's set for this afternoon.
Okay.
I'm just wondering, we also have we have the 26th of this month. Is there anything set besides Curtis Day? I have a Curtis Day second-degree murder case that Mr. Atchison is involved in, and it's set for sentencing here in this courtroom on the 26th. So I'm just wondering if that might be a better day. If we don't have anything else set for that day, right?
The 26th is fine.
All right, let's set it for that morning at 9 o'clock. I think we'll do the Curtis Day and then we can take this one up.
Okay, all right.
All right, so this one is Mr. Hansard's 412 motion. Is that the only thing that we'll be dealing with on that day?
Yes, sir.
Yes, sir.
Do we want to go ahead and set a trial date today, or would you like to get one?
I mean, that's fine. We could set a trial date. If you want to set one in January, then it might be the most appropriate.
Yes, sir.
We have given you trial dates. The conspiracy case general is still set for the 20th through the 23rd, correct? Is this a case, Mr. Hansard's case, one that we know for sure will go, and how long will it take to try it?
I think maybe a day and a half. I think it would depend on how long jury selection.
And I think 2 full days, Your Honor, is my.
2 full days?
Just to be safe.
Yes, sir.
What about the 29th and 30th? I mean, we've got stuff set. That's the reason I don't want to set anything unless it's for sure going to go to trial. Right now, I've got the 13th Greer. Sheets on the 14th. But if it's a 2-day trial, I don't want to set this one. So then we start the conspiracy case on the 20th, and it's going to go the whole week, correct? You know, are we trying it at some other venue? Are we trying it down in the jury assembly room where we can get all of the defendants in one location? Or are we looking for a gymnasium somewhere? In January, a football field will be a little bit dicey, I think. So, all right. Well, why don't we just set this one? And let me just ask this: if I assign a trial date, everybody understands it's going to trial, or he's pleading to every count of the indictment and going to sentencing. So, with that, you understand that, Mr. Talbot? I will set it for January the 29th and 30th. All right.
And then the motion.
Motion for 412 will be this month on the 26th.
26th. Thank you.
9 o'clock in the morning.
Yes, sir.
Yes, sir.
Okay.
All right, I'm sorry. Going back to you at the jail, we have appointed, let's see, who was this I was dealing with? Mr. Wainick is here, lawyer. Thank you. I'm trying to remember what, okay, we set it for status on January the 7th, and your lawyer will be up to talk with you and try to get you ready for either a disposition or a trial date will be assigned on January 7th. So Mr. Wainick will be up there to talk to you as soon as he's back in town. All right. I guess I could just tell him to talk to the other Roger Wainick there at the jail. Good morning. What is your name, please? You're muted. You'll have to unmute that device again. There's wherever the little microphone is, it's got a slash through it. Just punch on that.
There you go. All right, Dudley.
What is your name?
Jack Dudley.
All right, Mr. Dudley, you're here to be arraigned on a charge of probation. It's an amended charge of probation violation, and you've already got the public defender, so we'll appoint the public defender on this charge as well.
Your Honor, I acknowledge receiving a copy of the warrant and waive formal reading of the same and enter a plea of not guilty on behalf of the defendant.
This is presently set for October the 27th. Do you want to set this one as well?
Yes.
All right, October 27th. Your lawyer will be up to get you ready for that hearing. Thank you.
Thank you, Your Honor.
Good morning. What is your name?
Rubén Barrientos.
All right, Mr. Barrientos, ¿se habla inglés? No?
No, señor.
We'll need to get an interpreter.
Entiendo un poquito, pero es muy difícil.
Poquito español por moi is French.
Usted también habla un poquito español.
I am poquito español.
Bueno.
We're going to set let's put it on the regular arraignment day and make sure we have interpreter. We're going to get an interpreter for Espanol, and we'll reset you for the 22nd, September 22nd, 9:22. Gracias.
Gracias.
And that is the extent of my Spanish.
Did you see him?
Yeah.
You talked to him?
Yes.
Said, oh, they reset it? Hey, just a minute, I'm gonna go get your females.
All right.
I said, just a minute, sir, I'm gonna go get your females.
All right. Thank you. Why do I always feel like I'm on a situation comedy whenever we're doing this? Let me go ahead and see if I can run through any of the rest of these that aren't in jail. Looking on page 7, Mr. Atchison, State versus Donald Eugene Helms. It's for status.
Judge, sometimes when I pretend to be an attorney, I haphazardly look at a calendar and realize that Mr. Helms was set today for status. This came out of general sessions on remand. We did a preliminary hearing. This is General Lorjanowski's case. My 84-year-old client is at a doctor's appointment that he could not reschedule today, so I will follow on that sword.
So your 84-year-old client is charged with aggravated assault, is that correct?
He sure is, Judge.
All right. So what do you want to do with him? You want to put him on status on the 22nd?
Is it 20? That's fine.
Whatever you want to do.
9/29 sounds a lot better than horrendous.
September the 29th. Thank you.
Thank you, Judge.
All right. All right, at the jail, can you tell me what your name is, please?
Amanda Roberts.
Amanda Roberts on page 1. Ms. Roberts, you're here to be arraigned on a charge of aggravated burglary of a habitation, theft of property, falsely representing yourself as Roger Wanick, that's a neat trick, and financial exploitation of an elderly or vulnerable person and criminal information.
Yes, sir.
You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
I'll have to appoint a lawyer to represent you, and I'm going to appoint Mr. Philip Massengill. His office is in Asheville, but he's here on a regular basis, and I will appoint him to represent you. Let's ask if I could, Mr. Atchison, do you mind standing in for Mr. Massengill? I'm going to have a lawyer stand in for arraignment for Mr. Massengill, who's not here today at the moment. You wish a formal reading of the indictment?
Judge, we waive formal reading of the indictment, and on behalf of Ms. Roberts and Mr. Massengill, we would enter a plea of not guilty at this time.
Plea of not guilty is entered. I believe we've set it for status for January the 7th of 2026. Your lawyer will be notified of his appointment. He'll make an appointment to come see you as quickly as he can, and he will work on trying to get your case ready for a trial or for a disposition. On January the 7th is your final day to try to resolve it by an agreement. And if you have not worked it out by that day, I will give you a trial date. Okay? I thought for a moment she was just so entranced by my words that she was unable to speak or do anything, but I think we're frozen at the jail, so.
Thank you, Judge.
All right, let me go back to calling these other cases. Let's try this one. 2024 CR2, State versus Jeffrey Ty Hicks.
Judge, that is one of Mr. Baker's clients, and we have a motion. We'd actually previously given it a date along with Mr. Flanagan's client, Mr. Long. We had given it an October 7th motion date in Waverly. You had asked if we could move it up till today, and the officer that conducted this traffic stop is no longer in law enforcement. He's working, owning his own company, and he was not able to get work covered for today. So I'm asking if we could move it back to that October 7th date where we originally had it in Waverly at 1:30.
Right, October 7th at 1:30 in Humphreys County. So this motion will be after that. Is there a better day that we could choose other than that? Could we not do it on the 26th of this month? That's when I've set the Curtis Day in the Hansard Rule 412, and we can do your motions after lunch.
Maybe I'll reach out to my officer.
Mr. Flanagan, what about you, the 26th? That's what I'm talking about. We have these other things in the morning. That might be better than trying to do this one in Waverly. If we could check with your officer, we'll come back to it, okay?
Thank you.
I'm sorry, at the jail, could you have your device unmuted again? All right. This is Ms. Roberts, correct? Ms. Roberts, we've appointed a lawyer to represent you named Philip Massagill. He's going to be notified of his appointment. He'll be up to talk with you. And we've set you for January the 7th as your final day to resolve it by an agreement. If you don't work it out by that day, I'll set you a trial date. So. Did you hear all of that? Apparently not. Ms. Roberts, can you hear me? At the jail, we need to communicate with the jail, let them know that apparently they're not able to hear. Modern technology. I cannot hear you, and I'm not sure you can hear me. Can you hear me?
They're buffering or something. You can't hardly hear them.
Yeah.
Now we can hear you.
I don't know why this is off.
Apparently not.
He's got you muted. See that X? He's got his side muted where you can't hear him.
All right. Let's try to muddle through the. Mr. Flanagan, the Justin J. Long, is that the case we were just talking about? Okay.
22. Mr. Darden, the agreement is that it be dismissed upon payment of restitution in the court costs. So Monday, I want you to contact the clerk's office and get that figure.
So you want to put it on what day?
10/22.
October the 22nd?
Yes.
All right.
Get all that done.
There you go. I think we're hearing another case as well.
Thank you. Ms. Roberts, can you hear me?
Yes, sir.
Let's talk quickly before we lose you again. I've appointed Philip Massengill as your lawyer. He'll be up to talk with you as soon as he can schedule it. And I've given you a date of January the 7th as your last day to enter a plea if you work it out by an agreement. And if you don't, I will give you a trial date on that day, okay?
Yes, sir.
Wait for your lawyer to come talk with you. Philip Massengill is his name.
Okay, thank you very much.
Good.
Okay.
Come on.
Good morning. What is your name, please?
Tammy Lewis.
Amy Lewis is on page. Your lawyer, Mr. Lockhart, has had a death in his family, and as a result, we are going to move you to September the 22nd. And hopefully on that day, it can be worked out and everything can be taken care of on that day, September 22nd.
Thank you.
All right, thank you.
Come on, Dudley.
This one.
Good morning. What is your name?
Randy Dillard.
Ms. Dillard is on page 4. All right, Ms. Dillard, you're here to be arraigned on a charge of possession of contraband inside a penal facility or institution, possession of methamphetamine and public intoxication. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Public defender?
Yes, please.
I'm appointed the public defender's office to represent you.
Your Honor, I acknowledge receiving a copy of the indictment. I waive formal reading of the same, and on behalf of the defendant, enter a plea of not guilty.
Plea of not guilty is entered. General Bryson? We're going to set this for January the 7th for your final day to enter a plea. If you're able to work it out by an agreement, then we can take it up earlier than that day, but that will be your last day. After that day, we'll set you a trial date. The public defender will be up to talk with you as quickly as they can arrange to see what they can do about getting your case resolved. Okay?
Yes, sir.
All right, thank you.
Our Zoom is trying to shut it down.
Looking at page 11, State of Tennessee versus Mackenzie Brook Lion Meadows.
That's for plea, Judge.
All right.
Approaching the podium with me. Your Honor, in this case, subject to the court's approval, Ms. Meadows will enter a plea of guilty, Your Honor, excuse me. She'll enter a plea of guilty to the charged offense in this indictment of 1 count. The punishment on that, Your Honor, will be 2 years of probation pursuant to judicial diversion. She will be required to complete anger management and parenting classes as a condition of probation. She'll be responsible for the court costs. She has signed a plea sheet to this effect, Your Honor, and there are pretrial jail credits on here, and there is a certification of her diversion eligibility as well.
All right. Ms. Meadows, raise your right hand. Let's place you under oath.
I do.
Thank you. State your full name for the record.
Mackenzie Brook Meadows.
Ms. Meadows, you're here today charged with a single count of an indictment of child abuse or neglect. Have you seen or been shown a copy of those charges? Talked them over with Mr. Talbot. You and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter this plea of guilty. Do you understand that you can plead not guilty and have a speedy and public trial by jury in this court?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by using a subpoena. You understand that you would be presumed to be innocent at trial. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. I'm going to ask you to speak up a little bit. The lady in front of me is taking down everything that's being said and she's recording it. So it's important we get a verbal response. Do you understand that if you went to trial, I'm sorry, I may be repeating myself, but if you went to trial and you were found guilty, you could appeal that conviction and a sentence imposed to the Court of Criminal Appeals, have a lawyer appointed to help you with that appeal. Do you understand that?
Yes, sir.
Do you understand that by entering this plea, you're waiving your right to a trial and to an appeal? And all I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that's going to, we're going to talk about this. You're entering this plea under a specific statute for first offenders, people who have never been convicted or in trouble before. What that means is that you're going to be placed on probation for 2 years. If you successfully complete that probation, don't violate any of the terms and do everything that's required of you, then you can apply to have your record expunged at the end of that 2-year period. That means to wipe this off your record as though it never occurred. By contrast, if you violate the terms of your record, of your probation, this will become a permanent conviction on your record and will be there in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. Do you understand that?
Yes.
Do you understand everything I've explained to you thus far?
Yes, sir.
Do you want to plead guilty and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand that if you plead guilty, the court of the state may ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers can later be used against you in a prosecution for perjury if we determine that you have been lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
Yes, sir.
You understand I can't accept your plea unless I'm satisfied you are in fact guilty and there are facts to support it. General, are you going to supply the facts for me or?
Judge, I can supply the facts.
All right, I want you to listen then, Ms. Meadows, as the state tells me what their evidence would be at trial. Please go ahead.
Judge, law enforcement received a report in August of 2023 of an 11-month-old infant that had bruising about her body that was not consistent with normal child play or accidents. Through their investigation, they determined that the baby was in the care of the defendant at an in-home daycare that she cared for alongside her other children. And those are the basis for these charges that did occur in Dixon County. Judge, I would also like to let the court know that the victim's mother is present in the courtroom and has provided a victim impact statement for me to read on behalf of the family.
All right. Then I'm not asking that you necessarily agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to enter this plea according to this agreement?
Yes.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Talbot has done a good job of representing you competently?
Yes.
Mr. Talbot, do you know of any reason she should not enter this plea?
No, sir.
Then I will ask you to step back and have a seat so I can hear from the victim's impact statement. General?
My name is Alicia Crouch. I am the mother of Blakely Crouch, who was harmed before her first birthday, a time when she was too young to speak for herself or to defend her little body. No infant should ever have to endure harm, especially from someone entrusted with their care. The impact this crime has had on me as a mother is something I carry every single day. My trust, my peace, and my sense of security were ripped away. Emotionally, I live in constant fear that this could happen again, whether it be starting a new daycare, preschool, or kindergarten. That fear is something I will carry for a long time. At the time of the crime, it was especially hard for Blakely. She struggled with eating, taking bottles, and being away from people who made her feel safe. The aftermath was overwhelming. I had to take time off work to ensure she was cared for and to find a safe place for her. We attended follow-up appointments with her doctor and with child services. Even once I found a safe daycare, the challenges continued. Blakely did not trust the staff. She screamed for weeks before she was finally able to adjust. Blakely just turned 3. She is a smart, beautiful, energetic, funny, and loving toddler with a bubbly personality. I pray that she grows up with no memory of what was done to her. But as her mother, I will never forget the harm that was caused to my sweet Blake. Despite everything, I hope the defendant uses the resources provided by this court to reflect, learn, and do better. What was done cannot be undone, but what one chooses to do moving forward is within their control. My hope is for accountability, integrity, growth, and genuine change. The crime has left a permanent scar on my family. Thank you for giving me a chance to speak for myself and for Blakely today.
General, it's my understanding then that the victim, in the mother of the victim in this case, is in agreement with this disposition.
Yes, Judge, we met with her and with support persons to explain the process, going through everything, and we reached this settlement agreement together.
All right. Mr. Talbot, you and your client come back to the podium, please. Ms. Meadows, you've heard the very articulate and intelligent victim statement that was a powerful statement that was given by the victim's mother in this case. You still wish to enter this plea?
Sir.
You've heard her basically state that she hopes that you utilize this as an opportunity for you to reflect and to try to improve your situation and to make sure that nothing like this ever happens again. You understand that?
Yes, sir.
You understand that if you violate the terms of this probation, then you will not only have a conviction, but you will serve 2 years in prison as a result of this. You understand all of that? All right, then Mackenzie Meadows in docket number 2024 CR 230, upon your plea under 4035-313 to the offense of child abuse or neglect or endangerment, order that you be placed on probation for a period of 2 years. And the conditions of that probation are that you must complete an anger management and the parenting classes. You must pay the court costs. As a judgment of the court, you'll need to see the probation department.
Thank you, Your Honor.
Day versus Rebecca Ann Miles, Mr. Flanagan, that's at 2025 CR 59. An hour. All right, let me come back to it after I run through. All right. (2023) CR 101, State versus Samantha Marie Shelton. Samantha Marie Shelton, arraignment on a misdemeanor violation of probation. We have a bond on that person. Okay. Let's just, I don't know if the jail's frozen again or if there's just no one else that's necessary. We need to find out, I guess. Bring over, okay. Well, let's put Ms. Shelton on September the 22nd, just in case she is in jail. On page 17, 2023 CR 391, State versus Anthony Nathaniel Thompson. This is to get a new trial date, is that correct?
That's correct, Judge. And Your Honor, Mr. John Webb represents the defendant in this case. Mr. Webb was here earlier today and had to go to another county for court, so I'm making the announcement.
Okay.
This case is currently set for trial on September the 23rd. The state has another case that's also going to trial on September 23rd.
That's the James Wills case?
That's correct, Judge. And in that case, I think I have currently subpoenaed 19 people. Mr. Saul and I are both prepared for trial. So I'm asking the court to give Mr. Thompson a new trial date.
All right.
I think we have picked a motion day of January 7, 2026.
Okay.
And the trial date will be May 14th and 15th.
May 14th and 15th?
Yes, sir.
All right. So January 7th will be his motion day and May 14th and 15th will be his trial date, so.
Sure.
We'll put that down. Thank you.
Sarah Wojnarowski was also. What'd you say? I told him.
He's not. Okay, notify her, we don't have a, she's not in jail, so I don't know, she would have had to make a bond, I suppose. Although, or maybe she hasn't been arrested. Well, let's move it to the 22nd and see if they can locate her. So. They are? Okay. Then we're ready for, bring out the first inmate.
No. Right now, he submitted paperwork.
This is on page 8 of the court's docket, matter of the state versus Amber Marie Jensen.
All right, she is pleading to a violation of probation, and as a result, she would be ordered to enter the drug court program. And if she is successful at rehab, she would be reinstated. If unsuccessful at rehab, sentenced to serve, must complete the drug court, a zero tolerance, or a condition of her probation. All right, Ms. Jensen, if you'll raise your right hand, let's place you under oath.
I do.
State your full name for the record.
Amber Marie Jensen.
Ms. Jensen, you're here today on a charge of violation of probation or violation of community corrections. No, I'm sorry, violation of probation. Do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation?
Yes, Your
You
Honor.
understand that you would have the right to have a lawyer and have one appointed if you could not afford your own, which we've done with the public defender. You understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea, you're waiving your right to a trial, to a hearing, and to an appeal. And all I'm going to do is follow what your lawyer has worked out with the state. You understand that? Now, what that means is that you're going to be ordered to go into a rehabilitation program. And if you successfully complete that rehabilitation program, then you're going to go into the drug court program. You understand that?
Yes, sir.
This is a little tricky because I am revoking you to serve your sentence, but I'm ordering you to be allowed to go into a rehabilitation program. If you successfully complete that, then you'll be in the drug court program. If you don't, then you're going to be ordered to serve that sentence. You understand that?
Yes, sir.
And if you do complete the rehabilitation and you go into the drug court program, then you're going to be on probation and they're going to be monitoring you and you'll have a zero tolerance for any positive drug screen. That means one positive drug screen, you're going to go to prison for the balance of your sentence.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
I have been handed a recovery court entry order that purports to bear your signature. Is that your signature?
Yes, sir.
Did you, and Mr. Sensing, Mr. Howard, I'm sorry, Mr. Howard, go over the terms of that? Did you
Yes,
read
sir.
through it and do you understand everything that's provided in that?
Yes, sir.
And all of the rights that you're waiving, that you would normally have, you're waiving all of those rights to enter into that program.
Yes, sir.
But it's also conditioned upon your successfully completing the rehabilitation, meaning that you're not in the program until you successfully complete that rehabilitation. Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you wish to enter a plea according to this agreement and waive your right to that hearing?
Yes, sir.
All right, then I order that you be revoked to serve your sentence. I will order that you be granted a furlough to go into rehab. And as a result of that, depending on how you do, you'll be allowed to go into the drug court program. Okay?
Yes, sir.
Good
Thank
luck
you,
to
Your
you.
Honor.
Mr. Howard, I'm signing an order that says that this is a furlough for substance abuse treatment. And it says all legal matters have been referred to and accepted by the 23rd Judicial Recovery Court Program and for good cause shown. She is hereby ordered to go into the synergy, which she'll undergo, blah, blah, blah. She'll be released from the county jail and go into that. She'll remain at the treatment facility until subject to the order of this court. In the event she leaves the custody without the express, she'll report to the county jail to resume service of her sentence. Upon successful completion of the treatment program, the defendant will be placed on supervised probation, a condition of which will be successful. Now, in 2 weeks or a month, if someone were to look at the court file, would they know whether or not she's on probation or not? There's going to have to be an order, in my opinion, and it doesn't really matter to me because this is a broken record that I keep preaching about. If she successfully completes the rehabilitation, she's going to be on probation. But there's nothing going to be in this file unless a separate order is entered that places her back on probation. So, I mean, I'm just pointing out the fact that it seems to me that okay. And the court file will reflect whether she successfully completes it and is actually, the trigger is that she has to complete the rehab before she's in drug court. But I just signed an order putting her in drug court. It's just the same thing we run into all the time. Technically, she's not in drug court until she completes her rehabilitation. That's the trigger. And if she doesn't complete it, then she comes back to jail. And that's what that order says, but it's contradictory in its language because it also says that she's under the supervision of the drug court. But I think it's a necessary confusion because they have to be the ones to monitor whether she's in or if she is or if she ain't in rehab. So, all right, I just wanted to make my statement about that again. All right. Next inmate.
Your Honor, this is defendant Danny Sheets. That's going to be on page 14 of Your Honor's docket. This is our motion, my motion to suppress the results of a warrantless search and seizure.
Are we, this is for a hearing then?
I set it for today, Your Honor. I filed it, I think, middle or late last week, and I've spoken with General Sylvie. She said that her officer involved in this would not be here today.
Set today, date, so it was easy to go ahead and just set it for today.
You know when he would be available?
I think if we get it another day, I was hoping.
Send you a copy. It was just an opportunity.
How much do we have right now on the 29th? How, State versus Jimmy Reader, PCR, do we know time estimate, how long we think it'll take? On the State versus Jimmy Reader PCR that I have to hear, any time estimate how long we think it's going to take?
I filed a motion. I'll send you a copy.
I understand it's, your client is obviously, but
I'd say 4 hours.
you what?
Ours will not be 4 hours.
Agreed.
Well, I mean, I can give you the, we've set the 26th for motions. Several, we've already got several motions on the 26th. Would that day be? You want to do it on the 26th?
Yes, sir.
All right, we'll set it on the 26th.
Thank you, Your Honor. See you on the 26th.
Any sheets? I do. We're right there. Okay. We're ready for the next inmate. Morning, what's your name?
Chris.
All right. Put it on second call. Let's see. <clears throat> 23rd day of September.
Yes, Judge. Mr. Wills is here today. Pursuant to transport order that I had requested.
Right.
We discussed this case, talking to General Crouch about it. What we'd like to do is keep it set for the trial on the 23rd, but there's a second transport order that was sent by Your Honor for him to be brought back before the trial. So for today's purposes, we're finished with Mr. Wills. He can be sent back to TDOC, to special needs as discussing a possible settlement. We want to keep it set for trial on the trial date, and then we'll let the court know as soon as we may have a settlement agreement.
All right, it remains set for trial on the 23rd. You have an order already down for him to be retransported, is that correct?
Yes, Judge, there's a second transport.
All right, then we will see him on September 22nd.
Yes, sir. Thank you, Judge.
What else do we have back there? All right, Mr. Flanagan, who is your client that you had the motion on?
That's the state's motion to revoke. Miles?
Dave versus Rebecca Ann Miles.
Scared me.
All right, this is the state's motion to revoke bond. And it's my understanding it will be an evidentiary hearing, so you may call your first witness.
Pass up a certified copy from General Sessions Court in Dixon County. New arrest from August the 1st for Ms. Rebecca Miles showing domestic assault with the allegations stated therein. We may have rebuttal proof, but at this point, that's the state's proof for the direct purpose, Your Honor.
I object to admission of that document. Violates confrontation.
Your Honor, I believe literally out of this county with Judge Locker Mash, that went up to the Court of Criminal Appeals. The Court of Criminal Appeals ruled that that was sufficient on its own. I'm trying to get the exact case. I could find that out, but that literally came out of this very circuit court county, Your Honor.
I don't have the case in front of me, but I'm understanding that is the rule that has been adopted by our Court of Criminal Appeals. So as a result of that, I will have this marked. It is a certified copy. I'll have it marked as Exhibit 1, and that is the state's proof under the statute, which allows the state to seek the revocation of bond based on a subsequent arrest for a person who's on bond. Is that correct? All right. Mr. Flanagan, do you wish to offer any proof?
Maybe. This motion to revoke bond, and that's the DA's office here always styles it that way, but they leave off the other options. It's a motion to revoke, alter, or amend. So this thing that's been handed to you is now an exhibit is maybe sufficient to show that the bond condition has been violated. But the court has discretion on what to do with it. And so I think that's where we are. So if the court is now ruling that they have sustained that the bond condition has been revoked, then we'll go to what needs to be done.
Well, based on that case that Mr. Stevens has referenced, is in my own understanding of the current state of the law, a certified copy of a subsequent arrest record is admissible, and under the statute that the state is proceeding under, they have the right. It doesn't require conviction. It says anyone who is on bond or in bail and is arrested on a subsequent offense, that the court has the option of revoking their bond. So
Yep.
I think that the state has met its burden to show that there is a basis for the court to consider any revocation of the bond, or as you state, the statute allows for modification of the bond. So the state, in my opinion, has met its burden to show that there is a basis for review of the defendant's bond, either a revocation or a modification. So if you wish to offer any proof about that, then I'll be glad to hear it. So.
Well, I guess my position is now, has the state put on enough just with that to justify a revocation of the bond? I mean, that's all the proof you have before your honor. So you got three choices. You can raise the bond. You can put different restrictions on her. So my position is they have not met the burden to show that one of these other options is not appropriate. So I'm asking the court, as a matter of law, to alter or amend the bond.
So you're basically asking me to alter or amend it, okay?
Yes, because I mean, you know,
I understand what you're asking.
yeah, they
So-
put they put that.
Let me hear what the state's argument is. If we're not going to have any proof, then I'll let you both argue what you think the appropriate disposition is.
Well, let's do it this way. I can have just a moment.
You'll need to come around here.
Okay.
Would you state your name for the record and please spell it?
Shonda Vargas, it's SHONDA VARGAS.
Okay. Ms. Vargas, where are you employed?
Serenity Ranch Recovery in Mammoth Cave, Kentucky.
Serenity Ranch?
Yes, sir.
Okay. And has Ms. Miles already been admitted there?
Yes, sir.
And
Turn your microphone on.
a new charge you've already carried the burden on that, General. New charge has occurred. We're talking about disposition.
So just to clarify, is this, so as Mr. Flanagan seceded the point that his client violated the conditions of bond, and this is for the purposes of what to happen? Because at this point, I think it's irrelevant to whether or not she picked up new charges while on bond.
The court's already ruled in your favor on that, General.
I've ruled as a matter of a finding that I've made that the introduction of this certified copy is sufficient to meet the burden that the state has to show that there is a basis for the court to consider whether or not to revoke the bond. So I've made that finding. Mr. Flanagan is now wanting to produce proof that would offer alternatives to the actual revocation by offering, I'm assuming, some testimony that would indicate there is a basis for a modification of the bond, which is one of the options that the court has in this particular case. So as far as relevance, it is relevant, and I don't know, I haven't heard everything, but it's relevant as to what the defendant's present situation is and what, if any, modifications should be made versus revocation. So I'm going to, unless you have some other basis for the objection, I'm going to allow it to proceed.
Yes, sir.
Tell the court about the program.
It's a 28-day detox and residential program where we help individuals overcome substance abuse disorders. And we also deal with mental health, so we are dual diagnosis. After the 28 days, we do help clients go to the next step, which would be a partial hospitalization program, a PHP. We do help them get that set up if that is something that they are interested in to continue their recovery, to help them in that sort. We have therapy, we offer therapy, case management, and things of that sort, also group therapy. It's just kind of to get them to go on to the next step in there.
Okay, so she's been admitted.
Yes.
Been there a couple of days, right?
I want to say she's been there about a week, but I'm not
Okay,
positive
about a
about
week.
that.
And she'll be there for at least 28 days.
Yes, sir.
Could it be longer?
Not in our program, but we can set it up so she can go straight from our program to another program that would be 30 to 90 days.
Okay. And at my request, you brought her here today because you knew she had to be in court.
Yes, sir.
If she were to leave the program, would you notify me and or the district attorney and the court that she left the program?
Yes, sir.
That's all I have. For you.
Stevens, do you have any questions? You don't get off that easy. The state has the right to ask you questions.
This is kind of nerve wracking.
Good afternoon, or good morning, ma'am.
Yes.
Just a few questions for you. So when you go through that, are you aware of any of her prior charges as part of this when she goes into a program?
Yes, sir.
Okay. So you're aware of about 20 prior domestic charges?
I mean, I'm not personally, because I don't do the admission part. I work with the clients on a daily basis. That's all. That's my job.
Okay. What about 20 prior charges for violating conditions of bond?
Again, that's not my job. I don't do the admission part. I just help the clients when they come in.
What about 5 times failing to appear?
Again, that's not my job. I don't work with the admissions. I don't know what we know about her prior charges, but I do know that she had charges because we brought her to court today.
Are you aware she's a convicted felon for aggravated assault?
I mean, most people there are.
Okay.
Yeah.
That's all that I have. Thank you.
Nothing further this witness.
Thank you,
If the
ma'am. You
court
may step
doesn't have
down.
any questions.
Any other witnesses?
No, Judge.
State wish to offer any proof?
Her husband, Mr.
All right. Mr. Robert Miles.
Yes, sir.
So it has to do with the disposition. And Judge, before we get started, because I don't represent him. He is the victim in this. I think the state is going to ask him questions about what happened. And I explained to him that if his testimony here today is different than what he told the officers, he could be charged with filing a law. I don't represent him. And I told him I don't want to put him, that's why I didn't call him, because I didn't want to put him.
Mr. Miles, well, first of all, Mr. Stevens, are you intending to ask him about the factual basis of it?
I am, Your Honor.
Mr. Miles, you are the alleged victim in this case that's being used by the state as a grounds for the revocation of Ms. Miles's bond. In that, the officer who made the arrest is stating that you gave him information that, and I'll read this to you. It says, I made contact with Joseph Miles in front of the residence while Sergeant Mutter spoke to Rebecca Miles on the front porch of the residence. Joseph explained that him and Rebecca were eating Chinese food in Bellevue. Joseph stated him and Rebecca got into a verbal altercation at the restaurant. During the verbal altercation, Rebecca stabbed Joseph in the right hand with a fork. And then it also says that once you returned to your residence, Joseph stated that when he turned on Trace Creek Road, Joseph stated Rebecca started striking him in the face, chest, and groin. And I observed noticed a bruise under Joseph's right eye. So what Mr. Flanagan is wanting you to understand is that if you gave information to a police officer that they used in reliance on obtaining a warrant against your wife for domestic assault, and you are asked those questions today under oath, and you answer differently than that, there is a possibility that you could be subjected to criminal prosecution yourself, because there's a statute that makes it a crime to give false information to a police officer. Sometimes people get mad and they say things to an officer, they make a false report. And the reason they make a false report is because they're angry, upset, or whatever, and it's not true. But sometimes people decide they don't want to really, have to see what happens, so they want to change their story. But you have to understand that when you testify today under oath, then those questions, those answers could be used as evidence against you if you change your version of what happened. You also, as a citizen of this country, have a right under the Fifth Amendment of the Constitution to decline to answer any question that might tend to put you in danger of criminal prosecution. You understand that? You understand everything I've asked, I've advised you of?
I can decline the
You can
question.
decline to answer a question if you think your answer could potentially put you at peril for criminal prosecution. You can decline to answer because your answer might tend to incriminate you in criminal prosecution. Do you understand that? All right. You understand everything I've explained to you?
Yes.
All right. Mr. Stevens, you may ask.
Sir, please state your name.
Joseph Miles.
And Mr. Miles, how do you spell that for the record?
JOSEPH MILES.
Mr. Miles, who is your spouse?
Rebecca Miles.
And how long have you been married?
It's about 3 years now.
3 years. What was her maiden name?
Rebecca Fain. Fain.
How do you spell that, sir?
FAIN.
Did something happen to you on August the 1st that leads us to court today?
Yes.
And what was that?
We got in an argument at the restaurant.
About what?
She said that I was looking at a lady's butt, and I said I was talking about the bucket that had soy sauce on it.
Okay.
And she thought I was looking at the lady's butt.
Where was that at?
She
Was
got
that in
mad
Dixon
at me.
County or another county?
It was in Bellevue,
Davidson County, to your knowledge?
Davidson.
What did she do in response to that argument?
She hit me with a fork. I think that's what it was. I had my hand laying there, and she just hit me with it.
Did you have any marks from that?
I had a little scratch on my hand.
Okay. Still there today? Still there today with a mark?
No.
Okay. Now, Mr. Miles, did you drive home after that?
Yeah.
Where'd you go to?
Went home
And where's that at?
on Trace Creek Road.
Is that in
White
Dixon
Bluff.
County?
In White Bluff.
Okay. White Bluff, Dixon County?
Yes.
Now, on the way home, what else happened?
We argued, and it wasn't really a hit. She was just pushing, and I was kind of pushing away from her. And it was just a little altercation there, just back and forth.
Now, did you talk to an officer on scene?
Yes.
Officer sitting at court at a table with me right here?
Yeah. Yes.
Now, as part of that, what did you tell the officer happened?
I told him at the restaurant we had an altercation and just had the argument.
Did you mention where she said she was going to slit your throat at bed?
I think I might have mentioned that.
Multiple times?
I think I mentioned it once.
Okay. As part of that, did you tell the officer that she hit you right up there on that hill, right at the hill you can see right here, which would have been in Dixon County? Did you tell him that?
It was on the hill above the house.
So she struck you while you were in Dixon County?
Well, we was pushing each other.
Okay. You where she's on bond for a matter, correct?
On bond?
Correct.
Oh, yeah.
Involved striking a
Like the
school
red.
bus, is that correct? Striking a private school bus that caught on fire?
Correct, yes.
And you're aware she's a convicted felon?
Yes.
You're aware that one of the charges was she had a gun in her purse?
That, I didn't know she had a gun in her purse.
You didn't know that?
No.
Were people from the family calling Officer Lewis asking for the gun back before charges were made?
Her son asked me about the gun. It was his gun.
Okay. In her purse, correct? Or you don't know?
I don't know if it was in her purse.
What pills does she take? What medication does she prescribed?
That's medication, oxymorphone, and something else.
And she'd have a prescription bottle of that,
His
correct?
prescription.
Would that be in her purse as well?
I think it was in her purse.
Okay. And you're aware the charges include allegations of a child and bus driver on this bus as it caught fire that she hit. You
I didn't
understand
know
that?
there was a child on the bus.
You didn't know that?
Later.
Okay. 1 second, Your Honor. Well, they haven't stopped making it.
Close.
Mr. Miles, you and I have talked about your wife's substance abuse problems.
Sure.
And one of the things that you and I talked about, did we not, was trying to get her treatment.
Yes.
And that this altercation, she was somewhat under the influence of that. I mean,
Yes.
basically attacked you for looking at somebody.
Yes.
Okay.
She's very jealous.
Very jealous. Our goal, when I say ours, that what you and I had talked about was to try to get her in treatment to address that problem.
Right.
And you would agree that this new arrest is basically based on her substance abuse problems.
Yes.
And you want her to get help.
Yes, I do.
Okay, that's all.
Step down, Mr. Mull. State may call your next witness. Step right up here, Officer Lewis, and raise your right hand and be placed under oath.
Ma'am.
Sir, please state your name for the record.
Daniel Lewis,
And she may have already asked some of this, but how do you spell it?
DanielLewis.
Where are you employed?
Dixon Police Department,
How long have you been employed with the department?
almost 9 years.
You recognize the individual seated beside Mr. Flanagan at a defense table today?
Yes, sir.
Who is that?
That's Miss Rebecca Miles.
Based on your investigation, do you know of any other name that she has?
Miss Rebecca Fain.
Did you have an incident with her that brings us to court that occurred on or around January the 22nd of this year?
Yes, sir.
Where was that at?
It was at the intersection of 70 and 96, sir.
Is that in Dixon County?
Yes, sir.
Now, we're here at a motion, so what exactly was the basis? Did you get a call for service?
Yes, sir. We got called to an accident involving a school bus or a private school bus and a car collision.
Based on your investigation, what did it appear had happened?
From the investigation standpoint, we believed that Miss Miles was intoxicated during the wreck and hit the school bus, which ignited the school bus, making the child and bus driver get off the bus in a hurry.
Ms. Miles, did you ever collect blood from her, collect a blood sample for testing?
The hospital did, yes, sir.
Was that collected by you, sent off for testing at TBI?
Yes, sir.
What were the results of that for BAC?
I believe it was 0.113.
And was there something else in her body as well, oxymorphone?
Yes, sir.
Okay. Were people calling you about something for her? Was her family calling law enforcement?
Yes, sir.
And what about?
About a pistol we found in her purse.
Okay. Her purse?
Yes, sir.
What else did you find in her purse?
We found her prescription bottle of medication in there, along with some over-the-counter medications.
Okay. Was it, to your knowledge, was her name on the bottle? Do you recall?
Yes, sir, it was.
And the gun was in this purse with it?
Yes, sir.
Is she a convicted felon?
Yes, sir.
And what is that for?
Aggravated assault.
And to your knowledge, do you also have prior domestic assault convictions?
Yes, sir.
Does she have prior domestic assault arrests?
I believe so.
Okay, that's all that I have. Thank you.
Flanagan?
Depends. Law enforcement third, sir.
Third?
Yes, sir.
I know, I've represented, so now I'm on the third generation.
Yes, sir.
How long have you been an officer?
About 9 years, sir.
Okay. And based on some of the questions that you've been asked, you would agree that she's got a substance abuse problem, would you not?
I've only met her the one time.
Okay.
So I can tell
I
you from
understand.
what I know from that case.
Okay, I understand, that's all.
Thank you, Officer Lewis.
Thank you, sir.
Where is your father nowadays?
Retired building trucks. So
State has rested their rebuttal proof. Mr. Flanagan, do you have anything else to
Nothing
offer?
further, Judge.
I'll hear you in argument.
As you've heard from the testimony today, in January, an incident occurred around January 22nd. You've heard proof of that before, Your Honor, involving serious allegations of Ms. Miles under .113 along with oxymorphone, striking a school bus which caught fire with a child and a driver on it who then had to flee for safety. Additionally, inside of her purse is a firearm, and she is a convicted felon with a prior aggravated assault. Both of those are B felonies with a child endangerment under 3915-401D, as well as the 3917-1307 for the convicted felon. She made bond on this, was arrested and made bond shortly after, April 14th, 2025, for a 10-count indictment, including very serious offenses, which I've noted. She was arraigned on this on June the 16th of 2025, and a mere 45 days later, we have serious allegations of domestic assault. Her husband took the stand and noted how she stabbed him with a fork in another county, but then admitted to or spoke of pushing and shoving while right up the hill in Dixon County. Further, he admitted that he told the officer that she said she would slit his throat. The state has serious concerns on this case. We have someone out on bond on violent offenses with a firearm as a convicted felon. And while that matter is pending and on bond, she gets a new violent offense, a domestic assault, which you heard from Officer Lewis, she has a prior conviction on. Now, I understand the defense's argument that she just needs treatment. The state is in opposition completely. Treatment will not stop this in the sense of such serious violent acts. This is not simply one DUI. No, this is a very serious offense where a school bus catches on fire and then she gets a new domestic assault with prior history of the same while she's on bond, 45 days after being arraigned in Dixon County Circuit Court. The state therefore asks that you fully revoke her bond, and I believe she's already set for a status date in October. Thank you.
Mr. Flanagan?
Well, Judge, I understand that the assistant district attorney is anti-treatment. This is the first time he's ever really said it on the record, but I know he doesn't like it. That's the appropriate thing here. She's presumed innocent of all this other stuff. Your Honor can leave her in this rehab center for a period of time. We can set it back when we come to court. But she's presumed innocent on everything. And the knee-jerk reaction of the district attorney, especially in this judicial district, is always to revoke their bond. They don't even consider the other alternatives, and they don't even list them in their motions. But the appropriate thing I'd ask the court to consider, let these people take her back to Mammoth, Kentucky and finish that 28 days, and we can come back in and see where we are. But that's what I'd ask the court.
The risk to her family and to society at large is too great. Thank you.
Well, the statute that the state is relying upon is pretty clear. It's under 4011-141, which states that if after the defendant is released upon a personal recognizance and unsecured personal appearance bond or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or the proceedings, then the court may revoke or terminate the defendant's bond in order the defendant held without bond pending trial when without release. Subsection B is what that provides. Subsection A of that same statute does provide that when the defendant is released before trial shall continue on release during trial or released pending trial under the same terms and conditions as were previously imposed, unless the court determines that other terms and conditions or termination of release are necessary to assure the defendant's presence during trial or to assure the defendant's conduct will not obstruct the orderly and expeditious progress of the trial. When we set a bond in a case, I didn't set this bond to my knowledge. I had no input into the setting of her bond, but apparently one of the conditions that she was allowed to remain on bond or that she obtained no new bond conditions were to keep in touch with his or her attorney. The bond was set at $50,000. And then the issue becomes whether or not there is a basis for the revocation. There's no question that the state has produced and the court has accepted as evidence the fact that she was in fact arrested on another domestic assault. There's been testimony as to her prior record of prior domestic assaults, but the only real proof that I have is that she is a convicted felon from aggravated assault, and therefore that's the reason she's being charged with being a convicted felon. However, the nature of the offense for which she is on trial and the number of charges that she's facing, the severity of those charges, and the fact that there was a danger to a minor child involved in that accident requires this court to consider whether or not allowing her to be released remain on bond, even with treatment, poses a threat to the welfare and public safety to the extent that the court should revoke the bond. In considering that, the fact that she was indicted and brought before the court and less than 45 days later engaged in this type of domestic violence causes the court to believe that the bond should be revoked in full and that she is remanded to Sheriff's Department to be held prior to trial. The court is of the opinion she does need treatment, and treatment will be an option for this lady once we have disposition of the case. She is presumed to be innocent, but under these circumstances, the proof before this court from the officers involved seems to me that there's a fairly strong probability of conviction, which is one of the factors the court considers the nature and probability of conviction in determining the amount of bond and whether or not bond should be granted. Considering all of those things, the court is of the opinion that the bond should be revoked and she should be held prior to trial.
Yes, sir.
Motion for the state is granted.
Thank you, Your Honor.
And like that, one of the things I'm going to do is I'm going to file a motion for a furlough. You've taken her into custody, and I'm going to be filing a motion, and I'll have testimony from this same people and ask the court to furlough her. But I'll do that through a motion, just so you'll know what I.
All right. Who else do we have back in custody? All right, bring out Mr. Devaney. Mr. Baker still here? Mr. Baker? On Ricky Warren? Ricky Joe Warren, you have a motion to suppress, right?
I have a motion to suppress and a motion for a bill of particulars.
So that'll be for hearing. That'll be after lunch, obviously. So. August, it's set for what? September 25th. Okay. Yes. Who is the inmate?
Christopher Devaney.
I'm talking about.
Oh, I'm sorry.
A Department of Corrections inmate. We've got Wills and Warren. Okay. All right.
It's the same thing we just did on Tuesday. Judge, it might be confusing, but Mr. DeBenny, he has a pending probation
Turn that
violation.
microphone toward you.
It might be confusing, Judge. He has a pending probation violation, plus he has other charges. He'll be pleading guilty to the probation violation. Subject to Your Honor's approval, his sentence will be placed into effect. He will serve 1 year and then be released back on probation. On the new charges, he will be pleading guilty to theft between $2,500 and $10,000. He'll be getting a 6-year sentence, all suspended but 1 year. And that will run concurrent with his probation violation. He'll also be pleading to simulation of $10,000 to $60,000. He'll be getting an 8-year sentence, suspended all but 1 year. And he is to make restitution on the probation violation, restitution on both of those cases during the pendency of his probation. He'll have random drug screens. He'll have to pay restitution within time limits. So the total sentence would be 8 years, suspend all but 1 year, and then 7 years supervised probation.
All right, Mr. Devaney, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Christopher Michael DeVinny.
Mr. Devaney, you're here today on 3 different types of offenses, and I'm going to deal with your probation violation first. You understand that if you are charged with probation violation, you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation.
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty to violation of probation, you waive your right to that hearing and that appeal. And all I'm going to do is revoke you to serve your sentence for 1 year, day for day, and then return you to probation.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you wish to plead guilty to the charge of probation violation under these agreements?
Yes, sir.
Then I find you guilty of violation of your probation order that you be revoked to serve 1 year, day for day, and then return to active probation. In these other cases, in docket number 2025 CR 139, count 1, you're found, you're charged with theft of property, and count 2, you're charged with criminal simulation. Have you seen or been shown a copy of those charges? Talked them over with Mr. Overton, you and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to those charges according to this agreement. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury of those charges?
Yes, sir.
You understand that trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes.
You understand that trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Mr. Overton could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out on these cases.
Yes, sir.
But you understand that's going to result in convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I can't accept your pleas unless I'm satisfied you are in fact guilty and there's a factual basis to support them.
Yes, sir.
Then are you guilty of the count of theft? Are you guilty of theft?
Yes, sir.
What did you take? What did you do overall, I guess it would be? Why are you in jail?
It would be for Al-Anon business, and a customer sent me some money and I didn't complete the job.
All right. And then there's a second count of criminal simulation. Tell me, are you guilty of that?
Yes, sir.
What did you do to in that particular case?
It was all stems from the same. The same.
General Wojciechowski is going to let me know what the facts would be. The criminal simulation is a little different than theft. So what is the? I'll tell you what, step aside and let her stand at the podium and tell us what the facts are. So.
Judge, on November 14th of 2024, Mr. Devaney took a check over to First Federal Bank that had been made out to him for $9,850. Then on the 15th, he withdrew that check from the bank. This check was a fraudulent check. It had been actually made out to a different, to a like townhouse for a rent. It had not been made out to Mr. Devaney. It also had been made out to a separate amount. So the theft and the criminal simulation come from the altering of the check and the theft of the money. The bank actually did give Mr. Devaney the opportunity as well to try to repay the money, and he chose not to do that. And that's the basis of the theft and the
Thank you. That explains it for me. All right, Mr. Devaney, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Overton's done a good job of representing you competently?
Yes, sir.
Mr. Overton, do you know of any reason he should not enter these pleas?
No, Your Honor.
Then, Chris, anything further from the state?
On the plea sheets that he signed, that in regards to the violation of probation, from the years has 90 days to repay that.
Right, that is part of that condition. I didn't announce that.
In
so.
the first case.
All right. I failed to note that on the probation violation order, but there is a requirement that after you have served your 1 year day for day, that you will pay restitution within 90 days of the reinstatement of your probation. And that will be in full, and that will be a zero tolerance. What that means is that you must pay it within 90 days. If you don't, for any reason, then you'll go back to jail to serve the balance of that sentence. You understand that?
Yes.
All right. Then in docket number 2025 CR 139, upon your plea of guilty to count one, I find you guilty of theft, ordered that you be sentenced to 6 years Tennessee Department of Corrections to serve as a range 2 offender that will be suspended to supervised probation after you serve 1 year day for day in the Dixon County Jail. You're ordered to have drug screens at least one time per month and have zero tolerance for your drug screens. If they're positive, one positive drug screen sends you to prison. The order to pay restitution in the amount of $9,850 to First Federal Bank with a minimum of $100 per month towards restitution. That will be concurrent with your probation violation. In count 2 of that indictment, you're found guilty of criminal simulation, sentenced to 8 years, Tennessee Department of Corrections to serve as arranged to offender, suspended to supervised probation after serving 1 year day for day in the Dixon County Jail. Those same conditions will be required as in count 1. This will be concurrent to count 1 and in your violation of probation for an effective 8-year sentence with 1 year to serve day for day and 7 years on probation. All right. Thank you.
Thank you, Your Honor.
All right, what do we have left then?
Record in the matter of Mary McLean versus Colleen McPherson. Ms. McPherson is here. Also here is Pam Kirkland from Adult Protective Services, Tony Laughlin from Adult PS, part of Commission on Aging. And we don't have Doug Coleman today, but I had excused him. This is a property on Mooney Lake Road that the defendant was residing in. We had a big discrepancy as to whether rent was being paid or not, but I don't need to resolve that question to resolve this. The township says she can't live there, and we have several agencies that were attempting to help her find a place to move to. Ms. McCullough, have you found a place to go? Ms. McPherson, have you found a place to go?
I have 2 apartments that I'm very interested in. I had to turn in the paperwork. They know the situation. They have to do so many checks now, and it just takes time. One was waiting for the cleaning crew to get done, and they said they'd be done today at 4. So I have prospects.
All right. Ms. Laughlin or Ms. Kirkland, either of you got any update for me regarding this?
She's continuing to work on it. We've submitted probably 10 applications just in the last week. And she does have plans to get her stuff packed up with her daughter tomorrow. So she is making progress. She just hasn't been able to vacate yet.
That was Ms. Laughlin from Commission on Aging. All right, well, you have 10 days from today to move. So let's talk about that, and I'll advise you guys as well. I would note that Mr. and Mrs. McLean are here. Ms. McPherson is here. Everybody's here live. I find that you have 10 days from today to move. That would be September 22nd. After that day, you could be subject to being evicted. You'd come to the courthouse with $15 and ask the sheriff to do the eviction. I think you're actively attempting to move. You want to move. You don't want to be there. They don't want you there. This is not any hearing regarding money damages. It's just regarding possession of the premises. There's no lease. Normally, I would say you have to turn in your keys and give your forwarding address within 4 days of your moving. I'd simply change whatever locks are on there after she moves. I change the locks. I don't know whether you're going to pursue any money damages. There is no lease, so it's not a great case for that. At this point, you just want to get her out. I'm not doing any money judgment. Now, here's the key. You don't have to evict her on September 12th. You have the right to do that on the following day, the 13th. But I said this earlier today, if the moving van is backed up and she's in the process of moving, it might not make sense to do the eviction because it's messy. The sheriff comes out, they put all the stuff on the side of the road. It's much better if the tenant vacates on their own. She's got help from 2 possibly 3 agencies helping her to find a place to move to. There's funding available, but there aren't enough houses, period.
I have the funding.
Yes, I said
Housing
that.
Resources is paying 3 months rent and the deposit.
Yes, you're very fortunate. So many people don't have that.
Right.
But there's not enough housing and there's not enough subsidized housing. I don't know if you guys, there's a meeting, and that's probably not adult PS's purview, but they're having a meeting on Tuesday, September 10th, 9th, I guess that would be. I guess it's Wednesday, September 10th, at the Presbyterian Church to talk with all the housing providers and funding providers. And at any rate, you should plan on vacating there within the next 10 days. If they do that, the matter's done. I don't have a bailiff. And Elaine, what I'll do is I'll ask you guys to go out to the court office, each get a copy of this order. You got 10 days to move. You got plenty of help. Hopefully they can find a nice apartment for you, get part of your rent paid. Did you have a particular one you were interested in? What's the one where they were doing the cleaning?
That's in Kalamazoo.
All right. I'll tell you what, everybody just wait here and she'll bring copies back to us.
Judge Middleton?
Yes.
Can I ask that you maybe ask Miss McLean not to enter Miss Colleen's apartment when she's not there and videotape and send me videos of the home when Miss McPherson is not there.
There's no lease, so there isn't provisions of the lease. She's a tenant at sufferance, but she is a tenant. So absent her consent, you don't have the right to go in there. So let's just get through the next 10 days. Hopefully it'll be sooner than that. You can vacate, and as I said, I'm sure you won't get in this situation again. This was way more trouble than it was worth. All right. Meg, I've got Casey Villa from Golden Ponds, and I have I don't have the attorney yet. I was gonna put you in the breakout room with the attorney, but I think that's the manager. All right, so everybody's on the same page. You're gonna get out of there. You're not gonna go in her apartment for the next 10 days until she vacates. Yes?
You spoke a lot about health and safety the last time. We have 2 major concerns. For one, I did have permission to go in there, and part of the video was to show the deplorable conditions. Pam herself told me and Miss McPherson she belonged in a nursing home, that even assisted living should not be within her reach with her current conditions. There are hatching flies, maggots, filth, rodents. It's horrible as far as safety and health. I'll be able to get it cleaned up eventually. But
and that I believe you.
But her son is violent. He is a felon.
Is he there too?
No.
She tried to move him in, saying she needed him to care for her because she needed help, and got a doctor to give her an order that said he had to live there.
Well, you need to get out. Don't bring your son in there or anyone else in there.
He's trespassed. He hasn't been back out there.
We had to get a trespass order.
But I don't know how this place got so filthy, whether it was
It's
free or
not
not
that
free.
filthy.
I have
When it
video.
was
Stop. There's not something called not that filthy. If it's got flies and maggots in it, it's not.
I told her about the flies. They took the thermostat.
All right. I
When it was-
don't need to hear any more about it. You just need to get out.
Yeah,
So
exactly.
give her that. She and her supporters can leave, and then we'll wait a few minutes to have them.
Thank you.
If it's bad enough, it could have been subject to immediate health and hazard. And so Douglas Kuhlman sort of backed up a little bit, but theoretically I could have evicted her the next day. But the sooner this tenancy comes to an end, the better. All right, everyone, thank you.
Thank you.
Thanks, Your Honor. All right, you guys just stick with me for a minute and then we'll.
Oh, okay.
What do I do now?
Is he serving for?
Yes.
I wanted to make.
That isn't very good. Like I said, I was gonna go over these before I gave them to you. All right, thank you. I got things. You're supposed to be gone. Oh, I thought it was 2. I got bumped back.
Yeah.
All right, as I said, no good deed goes unpunished. I had a couple of these, including the next one. And so I'm sure you guys want to get out of this business. All right, they're probably gone. You guys are good to go.
Okay.
All right, thank you. Hopefully I won't see you in here anymore. Although you're welcome to come visit anytime.
I would like that.
Okay, I'm open all day from 8 to 5. Or you can watch it on YouTube. Thank you.
We have friends that watch no other TV but you. I'm serious.
Tell them thank you, but they need to get out more.
Good afternoon.
Thank you. Okay, well, you're a year ahead of me, so I'll catch up with you next year. All right, we have a 235 and a 215. Might as well stay where we are on Golden Ponds. I think we had some things like get resolved in between here. I did get a few things resolved between on our break. I had some leftover problems from the criminal docket and some other issues, so you're fine. Yeah. Yes, I pulled a couple of those off. I'll redo the whole thing. Yes. And we get abstracted to his driving record.
It was a crazy morning, Judge.
Well, I got a little blurry there at the end, but
I was feeling like you were getting hungry.
I
You kept
was.
talking about lunch.
Next time I'm bringing in my own cookies for everybody.
So if you